For orders, item number 1, CRLMA 155 of 2022.
Lords, this unfortunately has been dismissed on the grounds there were no instructions. Actually, the matter.
Kanungo,
Yes, my lords, I'm appearing.
you're not audible.
My lords, I'm not audible. Mic is open, my lords. Now am I?
Yes, yes.
My lords, this matter has been unfortunately dismissed as the council who had appeared said that there are no instructions. Actually, the matter is alive, my lords. If you kindly restores it, it may come up any day, your lordship.
No, hear it today itself.
My lords, can it be next week? I'll get all the documents, my lords. I have some more documents to file. Next week, my lords, I'll file the additional documents by Monday or Tuesday. Your lordships may kindly take it up next week, my lords.
Or it will just list the whole thing then. List the whole thing on 5th August.
5th August.
Supplementary list for admission, item number 2.
Please, Lordship. Lord, I appear for the respondent on virtual mode, Miller.
Yes.
If your Lordship would be pleased to kindly take flag D, which is the report of the mediation officer, Miller.
No, you were to sign something, I thought.
It's been done yesterday, my lord, and we've handed it over to the petitioner, and he was supposed to bring it on record today in your lordship's board.
We'll pass it over. He's not here.
I'm obliged.
All right.
I'll wait.
Lords, may I pray that in item 1, the interim order may be extended till next.
No. I'm not allowing the application yet. All right.
Supplementary list, item number 3.
Hello, can be called after next week, madam.
What?
Madam, Mr. Sangnadi out of station.
No.
After
This is all too casual, sir. You are before a high court.
my lord, after death ceremony of my father, I come to court from today.
Sorry. Not so casual, sir. Please.
Maybe next week, my lord.
No. Just argue. This is not your magistrate's court, sir, where you just walk in and say next week, 10 days.
My lord,
I'm out of station.
After death ceremony of my father, I come to court from today, my lord.
If you're not prepared to argue, I dismiss it. If you're prepared to argue, you argue. If you want to pass over, I grant a pass over. 3 choices. 3 choices. Pass over. All right.
Supplementary list, item number 4.
Your Lordship, this is an application for appointment of arbitrator. There was a lease agreement and certain dispute arose between the parties. For example, area rents has not been paid, termination, illegal adjustment of rental amount. As per 6(1), the security deposit was supposed to be refunded. These disputes are arbitrable, and there is an arbitration clause in the agreement, which is at page 41, Your Lordship, clause 18.
What's your objection to appointing an arbitrator?
Your Lordship, there's an objection of the pre-admissibility issue. Firstly, it is not maintainable. If you allow me 2 minutes.
Allowing you several minutes, sir.
Much obliged. So I refer to clause 18 of the lease deed, which is there on page number 41 of the paper book submitted by the petitioner. It does not provide for a specific procedure for the appointment of the sole arbitrator. It says that the arbitrator shall be appointed in accordance with the Arbitration and Conciliation Act 1996. Under section 11 of the Arbitration Act, the petitioner was required to provide us with a mandatory notice by providing us.
At the end of all this, if he had done all that, you would agree to an arbitrator.
At least we would have, Your Lordship, been given an opportunity to reject or accept a claim.
Right now, assuming he named an arbitrator and rejected it, what is the next step? What is the next step? He has named an arbitrator, he has followed all that, he's named an arbitrator, you rejected it. What is the next step?
It's a long opportunity for us, Your Lordship.
No, you are giving so much opportunity. You got an advance copy, you filed a counter, everything you did.
Yes.
Enough time to think. Enough time to think.
Yes, your lordship.
Ah.
But it's a loss of opportunity for us. It would have given us at least, the reason why I'm saying this
Please
is
have some
because,
tenable arguments. All these are not tenable arguments.
your lordship,
Ultimately, if the matter is to go to arbitration, you just have to agree on the name of an arbitrator. If you cannot, I'll name the arbitrator. As simple as that.
your lordship, but the section 21 notice was never issued to us.
Sir, at the end of all that, what will happen? What will happen at the end of all of that?
I will just, the notice
So,
which was
so
issued.
he will vehemently oppose the arbitration here. When he goes to file a civil suit, he'll file a section 8. What are you trying to get at? You can't have it both ways. Either you agree to arbitration, then I record your statement that when he files a suit, he will not oppose. Will you do that? You will not do it. You will again cite the same arbitration clause. This is all just for opposing for the sake of opposing.
But your lordship, the notice which was
You
sent to
can
us.
never
was a
say,
document
you
notice.
can never say if he has a grievance, he will have no remedy. There's no such argument available to you. Both of you agreed that there's a dispute, we'll go for arbitration.
Indeed, your lordship.
What are you getting at therefore? It's a pointless kind of objection. This is objecting for the sake of objecting, that's all. It has no meaning. What is your claim?
My claims is around 65 lakhs. Your lordship.
65 lakhs. So you agree to a senior lawyer,
Uh,
you'll appoint a senior lawyer of this court.
Milan Khan?
Let the lordship.
Or even a lawyer who's not a designated senior, will you agree to Pami Rath? All right, the court appoints Ms. Pami Rath, advocate as sole arbitrator to adjudicate the disputes between the parties. The arbitration will take place under the aegis of the arbitration center.
It's not required.
All the contentions of the parties are left open to be urged on merits of their respective claims and counterclaims are left to be urged before the learned arbitrator. All right. Oblige you. All right.
Supplementary list item number 5.
Sorry.
5, 6, 7. Your lordship last time directed my lord and file the counter.
During the course of the, I am filing a
What are you saying in the counter? So let's see that. You're opposing it or agreeing it? So basically, it's all on merits.
My lord.
What's your claim?
Claim my lord in 3 cases, my lord, or 33 lakhs. In the 3 cases, my lord, say 33 lakhs.
Each case 33 or total?
Total.
So you agree on a lawyer, sir?
My lord. My lord, Manoj Mishra or Ramakant Mahanti, your lordship, senior counselor. Manoj Mishra or Ramakant.
I may be allowed one time, my lord. The main conducting counsel is hospitalized. That's why.
All right, sir. Whatever you have said in counter, he cannot say more than that.
Yes, ma'am.
On arbitration, you have not opposed.
Ma'am.
These are the counterfeitives taken on record, having heard learned counsel of the parties, and without expressing any view on the respective contentions and merits. The court appoints Sri Ramakanta Mahanti, senior advocate, as a sole arbitrator to adjudicate the claims of the party and the counterclaims of the parties. The arbitration will take place in the aegis of the arbitration center. So 5, 6, and 7.
My lord. 3
Ah.
cases.
Oblige.
Supplementary list item number 8.
Malaj, I have just one prayer, Malaj.
Yes.
Malaj, item 1, I'm really sorry to disturb your lordships. Malaj, 5th, I have some personal problems. Can it be 29th, Malaj? Next
Of
week?
August.
No, this July 29th or 12th of August. Your lordship takes these matters.
12th. Okay, 12th August. All right. 12th August.
I'm sorry to disturb you.
No problem.
Item 8.
Please, my lord. My lord, I'm on behalf of the
It's come back with the remark addressee left. The notice has come back.
No, my lord, actually on the last occasion, my
Your
lord was
lordship may
used to
recall,
refer
lordship,
the
I
matter
appear for
to
the
mediation, my
opposite
lords. This matter was referred to mediation, my lords.
Lordship, I appear for the opposite party from the other side back to appear through virtual mode, your lordship.
Yes.
My lord said flag 10 is the mediation report, my lords.
Yes. Your lordship had referred the matter on the
Oh, I see. Sorry.
So, my lords, the mediation has failed, my lords, despite effort by the councils, my lords.
Correct.
My
So
lord,
now, sir, why don't you agree to arbitration?
my lords,
What's the claim?
his claim is amount of around 4.5 lakhs, my lords.
4.5
Lordship, I
lakhs.
agree for the arbitration. It's very nominal. The sum is around 10 lakhs what they're claiming.
And plus interest, my lord, the principal is 4.5 odd and rest is interest and damages, my lords.
All right. The mediation report has been perused. The parties have not been able to settle the dispute through mediation. Paragraph, having heard counsel of the parties, the court appoints Shri Santanu Sarangi,
Sorry, my lord.
SP Sarangi, senior advocate.
Definitely, my lord.
Uh-huh.
Few
Shri SP
names.
Sarangi,
Ma'am,
senior advocate, as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims. The arbitration will take place under the.
Lordship, I have just
Yes,
one
please.
request, Lordship.
Yes, please.
Lordship, I'm so sorry to interject. Lordship, my only request is if the arbitration can take place through hybrid mode if it's possible, because the opposite party is based out from
That
Gurgaon,
request you make
and
to
the
the
property is
arbitrator.
also
That's not a
located in
problem.
Gurgaon.
That's evidence there in the
Request to the arbitrator, not a problem.
But Lordship, it can be because
That facility is available in the center.
the
my lord.
counter claim
Chamber
is
is there,
also
my
The
lord.
quite
center
less.
also
It will
has that
actually
facility, sir.
increase more of the cost for the opposite party to travel to Odisha.
No. So the center has that
If
facility.
Lordship can indicate,
No, there should be no problem. The center itself has all these facilities. In fact, that's happening on a daily basis. Some people appear virtually. All right. Yes,
very well.
all right.
Lordship, I was actually not aware of the procedure. That's
All right, not a problem.
Supplemental list item number 9.
And the fees, Lordship, can be as per the fourth schedule.
No, that's the center has its own schedule.
Very well, Lordship. Grateful.
It replicates the act.
Very well, very well.
Grateful, my lord.
Very well. Grateful.
May I-
Grateful.
may I
Lordship.
please
I'm
to
very
honor?
grateful.
Item 9.
Item 9.
for the respondent.
Yes, my lord, I'm here. My lord, this is a case.
The deficit court fee has not been paid.
My lord?
Deficit court fee has not been paid.
Yes.
488 rupees.
Noting my associate is present in the court. We will check it up. But here is the case. If it is not paid, today itself we will clear it.
All right. Mr. Padi states at the outset that the shortfall in court fee will be made up today itself. All right.
But only I have some limiters there, my lord. What happened in this case? There is a 2 arbitration proceeding was filed. Arbitration proceeding was fixed to today itself. Let's me remember this. Our Honorable Justice Ganguly, retired Supreme Court judge, appointed the arbitrator, and another 2 judges are the company judges to proceed the case. What happened in this case? The mandate is completed. Thereafter, we are before the court, and their other side also coming and filing a application for the court for extension of arbitrator. We are to because mandate is complete, we are submit application. The mandate should be remunerated by the court, my lord. This is the situation. In the meantime, 19th was the last date. It was listed. My lord, our last occasion directed that both the parties should submit their application or pay to the tribunal. Then accordingly, it will be adjourned, my lord. Last occasion, it was granted. Thereafter, they came and withdraw their own application. Then they are insisting to proceed in the case. So my limited prayer before my lord that my lordship may pass a status quo order. Then next Friday, let's take up. I will remove the defect and we will have it finally.
So, but why don't you argue the main matter itself today?
My lord?
Why didn't you argue the matter itself?
Yes, we are ready, my lord. Because the deficit is there, 480.
No, deficit, I already recorded that.
Today we can remove it.
So remove it. Meanwhile, you argue it.
Yes, my lord. This is a case. My learned friend, Mr. Kashyap, is present in the court. He will assist the court, my lord. I am extremely sorry. I am in virtual mode.
All right.
If Kashyap will assist the court, he will start the
court. All right. Yes, Mr. Kashyap.
Yes. In this case, admittedly, there is an arbitration agreement. And pursuant to the arbitration agreement, arbitration tribunal was constituted, and pursuant to your lordship's order, we participate in the arbitration proceeding. Your lordship, I have submitted a brief date chart in my arbitration petition, that is ARBP number 11 of 2022. That is under section 14 and 15 of the Arbitration Act. Lordship, kindly see page 5 of the arbitration petition. The date chart I have given for a short look of the facts.
Where is the date chart?
Your lordship. Arbitration petition itself, page 5. Page 5 of the arbitration petition.
All right. Yes.
On 15/2/2019, the Honorable Justice A.K. Ganguly, by letter dated 15/2/2019, conveyed his acceptance of appointment as the presiding arbitrator. And on 27/2, the first arbitration sitting was held. Claimant filed his claim statement. Respondent also filed his statement of defense. And then a rejoinder was filed by the claimant. adducing some new facts without an amendment to the claim petition, for which there was an objection from the side of the respondent on 19/10/2009.
What happened after 17th March? Your list of days ends on 17th March. What happened after that?
Your Lordship, into this shortly. First time there was with consent of both the parties, it has been extended.
It's been extended by 1 year. By
yes, 6 months. Then after the
1 year it has been extended, sir.
Your Lordship.
On 12th February 2021, the validity of the tribunal has been extended by 1 year. On 12th February 2021.
Lordship.
12th February 2021, the validity has been extended by 1 year.
Yes, before that also by the consent of both.
No, it's all right. We don't have to now. Let's move on now.
Your Lordship. In the meantime, Your Lordship.
Then
what?
No, 1 minute. Is there any further extension of time by the High Court?
No, Your Lordship. There's two extensions, one by mutual consent of the parties, one by this.
No, there is an arbitration petition 2 of 2022.
Lordship.
May I assist your Lordship?
Yes.
Where the arbitration petition 2 of 2022 was filed by us under section 29A. We are a claimant.
Right.
Now, in the meantime, my Lord, the Honorable Supreme Court on 10th of January 2022.
Correct. Because of the COVID.
Yes. Excluded of the period till 15th of March 2022.
22.
Yes.
Now,
my Lord, accordingly, my Lord, my time got extended. Therefore, the second petition under 29A was dismissed as not pressed.
Right.
Because by reason of the Supreme Court's order, my Lord, I was within time, or
Right.
the entire proceeding was within time.
All right.
Now, thereafter, my Lord, in the meantime, my Lord, they have filed this section 14 application, 14 and 15 application before this tribunal. I'm sorry, before this Honorable Court.
No, what happens after 15th March?
No, after 15th March, there were sittings.
No. For the mandate of the tribunal, the Supreme Court's order takes you till which date?
Well, the Supreme Court's order takes it till 28th of February 2022.
That's all.
Yes. Look, if your Lordship permits me, a very, very short list of dates on this issue. What happens to the Supreme Court's order? Look, may I only hand up the copy? But only on this aspect, we got a few dates. 15th of March 2019, the learned presiding arbitrator accepts the request. Then 15th August 2019, 6 months for completion of pleadings under section 23 expires.
No. Till when can it go? Once you say the period 15th March to 28th February 2022 is excluded.
Yes.
Till when can the arbitration go?
But, give me a moment. But I made a calculation. But according to my calculation, it can go until 5th of October 2022.
5th of October 2022.
This is my calculation, excluding the period, Miller, which the Honorable Supreme Court has in that suo motu writ petition had excluded.
All right. We'll record that statement. So don't go beyond. There's only 2 more months left.
Yes.
You
only 2 more months left.
Delay is not only on one party, also there is other parties. The application I have filed before this honorable tribunal that has never been considered. Though there has been recorded order by this honorable tribunal that these applications, these objections that have been filed by me, by the claim respondents, will be taken up in the next.
What are your applications?
Your Lordship, kindly see Annexure 1, Your Lordship. I filed these applications. What happened in this case, Your Lordship? Several documents in different stages have been filed. Even after admission and
what are your applications for? You tell us what the substance of your application is.
Substance is new documents which have been filed after admission and denial of documents. Even with the evidence affidavit, also few documents have been filed. So I objected that such documents cannot be taken into consideration by the honorable tribunal.
All right.
Despite that, without deciding upon all those applications, that objections that have been I filed, the arbitral tribunal continue on the.
That's all right, sir. Whenever the award is made, you can challenge the award on all these grounds.
Yes.
Well, also in this case,
my lord, what happened in the, I just 1 minute I'm interrupting. It is a tender of 100 crores, but claim is 4,000 crores.
It's all right, sir. All that the arbitral tribunal you can do.
The arbiter will decide what is the outcome. But problem is this: whatever document were cited upon before the arbitrator, and evidence is adduced in this respect, that was not taken away by the arbitrator. This is the whole problem. That's why.
Sir, this is not an appellate court for those individual orders.
That's why, my lord, what I am saying, my lord, extension of mandate is not an issue, or it is prerogative of the court.
No. If the arbitrator has not done what the arbitrator should do, You will assail it when the award comes.
My lord, it is beyond their period of.
No, period wise. So period wise, the Supreme Court has, because this is the COVID period, the Supreme Court has excluded for the purposes of limitation even for 29A this entire COVID period.
Supreme Court.
There are orders of the Supreme Court, so that takes the arbitration up to October. So let us not that part. I may not be able to agree with you that the mandate has ended because of limitation.
My lord, the Supreme Court once said we can't stand on the way.
Correct.
But the thing is this: on 2019 onwards, it is not that we have not abided the order of the Supreme Court or not extend our cooperation with arbitrator. We have twice. Once they have extended. Second time, because of the COVID, we were also we have given our consent to extend. And it was within the purview of the Supreme Court what extension given the Supreme Court earlier. It was already been complied with. It is not the case that we are not complied with. Here is the case is that after completion of the mandate from so many times, and there we are reducing a lot of things which are not taken into arbitrator. And this after completion of the arbitration mandate, they can proceed by ignoring our documents. This is the whole issue here that should be decided by the Honorable Court, my lord.
All right.
What I am saying, my lord, what I am praying, my lord, is it proper, my lord, either to LCR the maybe Kalfar or I may be allowed to time will produce the record. Thereafter, Lordship may pass it.
No. For 14, 15, all that is not necessary, sir. It's not necessary.
Your Lordship, it's the order of the Honorable Arbitrator itself. Then the next sitting, the objections which we have been given by the respondent will be taken up. But it was not taken up. And the witness is being, the whole question, the issue is, Your Lordship, if the documents are not marked exhibits, if the documents are not relied upon by the, considered by the both the parties, or it is not taken into record by the Honorable Arbitral Tribunal, then those cannot be put into question to the witness.
So what will ultimately happen? Let us say that all that is not taken into account. Whatever your applications are, those are not dealt with. And an award is passed, correct?
Right.
Are you going to be remediless?
No, Lordship.
But may you assail the award, correct? You will say ground A, ground B, ground C. One of the grounds will be, I filed so many applications, the tribunal never considered those applications. That will be one ground.
Your Lordship. But beyond time,
this is not an appellate jurisdiction. I think the mistake you're making is 14, 15 is not for an appellate jurisdiction saying arbitrator has not done this, issue a mandamus to ask the arbitrator to do that. That is not scope of 14.
But Your Lordship, kindly may be allowed to, I may be wrong, but may I be allowed to submit the section 14.2?
Yes.
With Your Lordship's permission, Your Lordship.
Yes.
Failure or impossibility to act.
That's very different, sir.
Right, sir. Different. You will also kindly see section 2, subsection 2. If a controversy remains concerning any of the grounds.
You are unable to perform. It is just that, like, within a jurisdiction, you have jurisdiction, but you don't exercise it properly.
Your Lordship,
that's only a ground of appeal or review.
Your Lordship, error of law can be cured at any stage, but this is error of procedure, Your Lordship.
Because error of procedure will only lead to assailing an award on the ground of error of procedure. So you're not without a remedy, sir. So this kind of provision is for a very different purpose. Let us say this arbitrator has been an advisor to this party, right? You did not know of it. You have suddenly come to know of it. You are telling the arbitrator you better do not associate yourself. He is not taking up that application. That is a valid ground because that goes to the root of the matter, right? It attracts all those prohibitions in the schedule. This is not so casual saying, oh, he's not taking up my application, he's not passing an order on my application. 14, removal. It's not that.
But my lord, that's simultaneously honorable arbitrator also not considering the section 18 of the Arbitration Act, my lord.
Sir, all very good news for you. Sir, very good grounds for you when you want to challenge it.
My lord,
under 34.
14.2.
You're stacking up your grounds very well then.
So what I'm praying, my lord, keep it to next week.
No. We are not adjourning, sir. Anything other than adjournment you can argue. All your wonderful arguments I'm prepared to hear, sir. I am not in a hurry.
No.
I'm only reluctant to adjourn. That's all. I've got a lot of time. You have a lot of time. You have two counsels. You're firing on two ends. One online, one in.
I am
physical.
actually sorry, my lord. I should present.
We're hearing both arguments. It's going very well, sir. Please carry on.
My lord, this section 18, let's me say for a moment.
Ah.
What we have advanced the argument earlier, Mr.
Ah.
This section 18, equal treatment of the parties.
Yes.
Parties shall be treated with equality, and
Yes.
each party shall be given a full opportunity to present this case.
Correct.
In the
Correct.
case, we have filed 3 applications.
Right.
One way we are praying that all the applications should take into consideration.
Right.
The arbitrator is not extending that because the mandate is going to complete, for
Right.
which your application cannot be taken into consideration.
Right.
We are saying that because the mandate is already completed, still then we are
No, the mandate has not been completed. So I think that's the first, because of the Supreme Court's order.
Before
They
that,
can't take it that the mandate has been completed.
Again, I'm
Let us see the situation in October.
No, my lordship.
Then you may have a case.
This is coming. It was coming in the period of notification is coming in the period of COVID itself. Period
Yes.
of COVID.
Correct. Correct.
Prior to that, it was already been expired. Man.
Right.
Prior to that, it was expired.
Right.
It was extended so much for 6 months. Thereafter, again, because the notification COVID period is continuing, we are giving our consent for extension.
Correct.
Then we are coming to the court.
Correct, sir.
It is
Correct.
not a case that first time it was completed and we are objecting and we are changing the mandate. It is not a case.
All right.
My lord, this is the thing which are these applications are filed before the arbitrator, and they are violating section 18 and not considering the same, for which we are invoking 14(2), and section 15 application is filed for the arbitrator. This is
All
the
right.
issue.
All right. All right. This is an application by the East Coast Railway under sections 14 and 15 of the Arbitration Conciliation Act 1996 bracket Act, praying that the mandate of the arbitration tribunal, a 3-member arbitration tribunal, which has been constituted to adjudicate the disputes between the ECR and the opposite party and the respondent, be terminated. Paragraph. There are 2 limbs of arguments advanced by learned Mr. P.K. Padil, learned ASGI, and Mr. Kashyap, Mr. S.S. Kashyap, learned Central Government Council. So one is that by effects of time, in the absence of extension of the period for completion of the arbitration proceedings under section 29 capital A of the Act, the mandate of the arbitrator has ended. So the second leg of argument is on a reading of section 14 bracket 1 bracket A of the Act, read with section 14 bracket 2 of the Act and section 18 of the Act. The arbitral tribunal should be declared to have become de jure, unable to perform its functions, because it has failed to take up for consideration certain applications filed by the ECR before it, objecting to the receipt of documents by the tribunal from the respondent in support of its claims. You are the claimant.
Yes.
Support of his claims. Paragraph. Mr. Dattal and senior counsel appearing for the opposite party, respondent, opposite party. Refers to the orders of the Supreme Court of India passed on 10 January 2022 in suo motu writ petition civil 3 of 2020, whereby the COVID period that is 15th March 2020 to 28th February 2022, was held to be excluded, even for the purposes of calculation of limitation in the context of Section 29 capital A of the Act. Full stop. As a result, Mr. Datta submits, notwithstanding that the opposite party itself had earlier filed arbitration petition 2 of 2022 in this court under Section 29 capital A of the Act, asking for extension of time for completion of the arbitral proceedings. In view of the above order of the Supreme Court, the opposite party, in fact, withdrew the said application. Full stop. As per Mr. Datta's submission, after applying the aforementioned order of the Supreme Court dated 10th January 2022, the period within which the arbitral proceedings should be completed, the date for which the arbitration proceedings should be completed, works out to 5th October 2022. Full stop. That way of the matter, according to Mr. Datta, it cannot be said by effects of time the mandate of the arbitral tribunal has come to an end. Paragraph: on merits, it is submitted that whatever grievance that the ECR may have about the conduct of proceedings, it was always open to the ECR to assail, to reserve such grounds in the event that the award is adverse to the ECR in any aspect, and it is required to challenge it under Section 34 of the Act. Paragraph: the above submissions have been considered. On the first aspect, on whether the mandate of the tribunal should be held to have been terminated by effects of time, the court finds that prior to the onset of the COVID period, that is 15th March 2020 onwards, the time for making the award stood extended on 1st March 2020 by 6 months, with the consent of the parties. Full stop. In normal course, therefore, the expiry of 6 months, with effect from 15 July 2020, the mandate would have ended. Full stop. However, the COVID period intervened, and the entire COVID period, that is 15 March 2020, 28 February 2022, has now stood excluded for the purposes of limitation in terms of Section 29 capital A of the Act. Full stop. The court is not presented with any counter calculation by the ECR to dispute the fact that the time for completion of the arbitral proceedings and pronouncement of the award stands extended up to 5th October 2022. Stop. In that view of the matter, it cannot be said that the mandate of the arbitrator has come to an end because of non-extension of time for completion of arbitration. Paragraph. As far as the proceedings before the arbitral tribunal itself is concerned, if there are procedural lapses, as contended by both Mr. Pari and Mr. Kashyap, then it will be open to the ECR, if it is so required to do, to assail the award if it happens to be adverse to the ECR on such and other grounds that may be available to the ECR at the appropriate stage. So the court is not persuaded that merely because the arbitral tribunal is not yet passed orders on the applications of the ECR, for whatever reason, the provisions of Section 14.1 bracket B, read with Section 14.2 and Section 18 of the Act, straightaway get attracted. Stop. In the present jurisdiction, while entertaining an application to Section 14 and 15 of the Act, this court is not acting as an appellate authority or a revisional authority. It is also not required to issue mandamuses to the tribunal on whether it should or should not deal with an application that is pending before it. Full stop. Certainly, these are not matters within the scope of sections 14 and 15. Full stop. To reiterate, the scope of section 14(1) bracket A is only when the court is satisfied that the tribunal has become single quotes de jure or de facto unquote unable to perform its functions. Full stop. The mere failure to consider an application pending before the tribunal at any time prior to the termination of its mandate would not command the considered view of the court, straightaway attract the conditionality spelled out in section 14 bracket 1 bracket A without anything more. Full stop. It must be recalled here that the tribunal began its sittings.
First sitting was 27th of February 2019.
Yeah, 27th February 2019. And keeping in view the COVID period, it cannot be said that the arbitration proceedings have been unduly delayed because of the acts of the acts or omissions of the tribunal. Full stop. Therefore, for the aforementioned reasons, the court is not satisfied that any ground has been made out in terms of section 14 bracket 1 bracket A, read with section 14 bracket 2 and section 18 of the Act, requiring the court to exercise its jurisdiction to declare the mandate of the tribunal as terminated. Paragraph. The court clarifies that it has not expressed any view on the merits of the contentions of the parties on their respective claims and counterclaims, or even on any of the other grounds urged regarding alleged procedural lapses of the tribunal. Full stop. These are matters on which it will be open to the parties to advance their contentions at the appropriate stage after the award is pronounced by the tribunal.
But only one request, Miller. 7 adjournments were taken by them, even on grounds like the lawyer's brief is missing. 3.5 months extra taken for filing SOD and survey joint.
That have taken. It is not that we have taken time. They are also taking.
It is both. No.
COVID
We
period
are
we have
close for once because our witness died.
It's okay, sir.
It is
The
sorry.
tribunal knows how to deal with all that, sir.
Yes.
The tribunal knows how to deal with it.
Only one line, if the Lordship may kindly consider to add, not to take any unnecessary adjournment.
No. That we don't have to say. There's already the statute which puts a time limit.
Yes.
I will also may I play one thing, that these applications which are pending, we are open to play, but you also may give us liberty to place those applications with the tribunal, because otherwise.
What happened? It's already there.
Witness action is over so far as we are concerned. Now their second witness
Since 18 January 2020, these petitions are pending.
Because we can't issue mandamus. You just heard me dictate an order. It's all right. The petition is accordingly dismissed. All right.
I'm grateful.
Supplemental list item number 10.
Item
10.
I am for the petitioner here.
Today we are ready and we are filing counter. Mr. Guru is there. Rai Guru is there. He is ready with the counter. And it will be filed today or by tomorrow.
All right. Mr. Pari says the counter affidavit will be filed today.
Yeah, already
Rejoinder will be filed. They've already filed.
Already filed by e-filing.
So what have they said in the counter? You've seen the counter?
First hour we have filed.
Sir, you are appearing for the petitioner or respondent?
I am appearing for the petitioner.
The respondent always has one online and one physical.
Miller, I am for the petitioner. I don't know.
Actually,
All right. Do you have the counter? Copy of the counter?
Millers, I have the copy was served on 5 minutes back actually, Millers.
Okay, what do they say there? They agree or
They are saying on the 2 grounds, Millers. One is that they have appointed a panel of arbitrator. My response to is that it is beyond Dattar switchgear judgment, which says that once I have approached 30 days has passed and I have approached this honorable court for appointment of an arbitrator, they cannot appoint an arbitrator.
Correct.
Point number 1. Point number 2, they are saying that I have obtained some no claim certificate, and I have given some no claim certificate that we have constantly denying. There is no claim certificate has not been given. The no claim certificate has also not been annexed to certify that the no claim certificate has been given. Because that's to prove down.
Mr. Pari, this no claim certificate can also be examined by the tribunal.
Yes, Millers.
May I-
What is your claim?
My lord.
Mr. Dwivedi, what's your claim?
Milords, my claim, I'm just heading, I'm just heading the heads of the. Milords. Milords, may I draw Lordship's attention to page.
No, you just tell us what the claim is.
Yes, Milords. Just, it's very bulky, Milords. That's why it's, I'm running from here and there, Milords. Milords, first claim, total claim, amount of claim, Milords, or Milords asking the head of
Amount.
Milords, it will come around 12 to 14 crores, Milords. So, Milords, I pray for a judge of this honorable court to be appointed. Milords, may I suggest, Milords, Dr. A.K. Rath, Milords.
Yes, Mr. Parikh.
He has no claims.
All right. An objection has been raised by a twofold objection has been raised by the opposite party, East Coast Railway, bracket ECR, to the appointment of an arbitrator, as requested by the petitioner. So the first is that the ECR already has a panel of arbitrators, and therefore one among them should be appointed as the arbitrator. Full stop. Paragraph is seen that prior to the petitioner filing the present petition, notice had already been issued to the ECR, and on account of its failure to respond to the said notice, the present application had to be filed. Full stop. The stage for, therefore, the ECR insisting on one of its panel arbitrators having to be appointed is already crossed. Paragraph. The second objection is that the petitioner has already issued a no claim certificate to the ECR, and therefore its claims are not maintainable. Full stop. This is opposed by Mr. Dwivedi, learned counsel for the petitioner, who states that there are no such no claim certificates and documents in this regard have not been enclosed with the reply. Full stop. Be that as it may, the court is of the view that this contention of the ECR can well be examined by the sole arbitrator to be appointed by the court. Paragraph. In that view of the matter, the court appoints Justice A.K. Rathur, a former judge of the court, as sole arbitrator.
Milords, Dr.
Dr. Justice A.K. Rathur, former judge of this court, as sole arbitrator to adjudicate the claims between the parties, including the claims and disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration center. Right, sir. Petition is disposed of.
Much obliged, Milords. Much obliged.
Supplementary item 11. In this case, I am appearing today for the opposite party, my lord. So I pray some time to file the counter, my lord. The dispute between the son and the father.
Will you go for mediation?
Arbitration
was already underway. This is an application for appointment for a substitute arbitrator, my lords. Due to various reasons,
that was unilateral appointment, my
I'm
lord.
still asking, will both of you agree to go for mediation to start with? It's after all father and son. Why can't you attempt settling a dispute through mediation?
My lord, now, presently the opposite party is an octogenarian and he petitioner is the third son. And for forgery of this agreement, police case is going on, investigation is going
Sir,
on.
what is your answer to the question I just now asked?
Well, next week, let it come next week. I'll consult my client, then my lord.
Sir, I'll pass it over. Your client may be octogenarian, but he has mobile phone.
Oh, yes.
Please call him. Tell him there is one judge who's asking whether you'll sit with your son in the presence of some senior mediators in a nice, beautifully furnished mediation center.
My lord,
Just for 1 hour.
I will convince, my lord. I will convince.
All right.
I will convince.
All right. The court is of the view that both parties, being father and son respectively,
Son and father, my lord.
son and father respectively. I've simply said both parties, sir,
My lord, yes.
should attempt settling the disputes through mediation. Accordingly, the parties are requested to appear at the High Court Mediation Center at 3 p.m. next Saturday.
My lord.
All right. 6th August. at 3 p.m. The coordinator of the arbitration center requested to assign the mediation to a senior mediator. The report of mediation will be placed before the court on the next date. 26th August.
Madam,
Deeply.
Supplementary title note 12.
Yes, may I please lordship, my lord. This criminal revision, my lord, I am VC, my lord.
Yes, please.
Listen, this criminal revision has been directed against the concurrent finding of both the courts, my lords, thereby convicting the present petition under section 395 IPC and sentenced him to undergo RI for 7 years, ma'am. That the main contention before my lord is that, admittedly, my lord, entire prosecution case solely hangs on test identification period, my lord. Admittedly, my lord, FIR has been registered against unknown persons, my lords. Admittedly, my lord, nothing incriminating materials were recovered from the possession of the present petition, my lord. Entire prosecution case solely hangs on the evidence of that investigating officer PW11 and that PW12 and learned magistrates and some of the witnesses, those have identified that present petition in TI period, my lord. My first contention before my lord is that there is an inordinate delay in the holding in the TI period, my lord. I want to invite my lord's attention that evidence of the investigating officer, my lord, who has been examined as PW11, my lords. PW11, my lords, may I kindly take a pen.
Yes, my learned friend was required to serve copies of the depositions in view of the last order.
We have already served on the day of filing the criminal revision, man.
No, it was ordered on 13th May 2022.
Whole problem is the old division and.
Sir, 13th May order do you have, sir? Mr. Das.
I bow down with my lord, very old divisions, my lord. Basically, I tried my best, my lord.
No, 13th May 22. Sir, I passed an order on 13th May 2022. Do you have a copy of that order?
Only that my judgment are there, my lord, lordship, direct.
Sir, should you not get a copy? This is your own petition, sir, and we are passing orders. Should you not get copies of those orders?
No, that orders are not yet available, my lords. Lordship, direct.
So what should we do? Should we now supply to you copies of orders in your own petition?
Only judgments are available. I will make.
Sir, I am asking you, orders passed by this court in your petition, should we supply copies of those orders to you?
Yes, lordship, direct.
I see. You will not apply, or you will not go on the net and see the orders passed in your own petition.
It's not there, man.
Is it asking too much for the lawyer, for the petitioner to say, sir, please see the orders passed in your petition?
Sorry, ma'am.
No, so what is the answer? You want us to supply you, or you will yourself see the orders?
We will just make a prayer for certified copy and get in and supply the state council.
Sir, what? I am talking of orders passed in your own petition.
That is not, I mean,
you do not know how to see those orders.
No, there is a mistake on our part, non-supplying copy to the state council. I go down.
All you have to do, sir, you have connected on the net. Obviously, that is how you are appearing in virtual mode, correct?
Yes, ma'am.
You ask some colleague of yours, young colleague in your office, he will go on the net. The order passed by this court in your petition, all available on the net. All right.
You
have to just see that order and act according to what is said in that order. The order dated 13th May very clearly says, Mr. Das, Additional Standing Counsel, states that he does not have copies of the depositions. And you, appearing for the petitioner, undertakes to serve it on him 1 week prior to the next date. This is the order. This was passed in your presence.
Right, my lord. But due to my unable circumstances, we are not able to supply. Let's fix a date so that I can make a plan.
Mr. Das, learned counsel appearing for the petitioner, seeks some more time to comply with the order dated 13th May 2022. Sir, my only request to you is the 13th May order and today's order, kindly download it from the net. Kindly keep it in your file.
Yes, madam.
Next time, please don't tell me I have only the judgment, I have no orders passed.
No, madam, that is not there. That is, I go down for my mistake, madam.
All right. All right.
Your old criminal
It's
division.
more time to comply with the order dated 13th May 2022 and supply copies of the depositions to learned additional standing counsel of the state, and also place it on record. 26th August.
My lord, we will get certified copy, my lord. Lord, see, my urgent some more date, my lord. Certified copy. Within this period, you may not get, my lord. So, Lord,
So you will get, if you're so minded, you will get it, sir. 1 month is more than enough.
It is all right.
It's a 2006 matter.
No, the date. I know the date. 26th August. Okay. Supplemental list passed or matter for admission, item number 2.
Item 2, my lord. We have filed the joint affidavit in the court today, my lord. We have filed as per the mediation, the both parties have entered into a
The
compromise.
joint affidavit of both parties
Dated
filed
21.
today in court and is taken on record. Both parties are bound by the terms agreed in the mediation, which have been set out in the joint affidavit of compromise. Will stop, the petition is disposed of in terms thereof.
Liberty may be given if any.
Yes. If either party deviates from the agreed terms, it will be open to them to apply for directions.
Deeply obliged.
Deeply obliged. Item number 3.
In item number 3, my lordship, on behalf of Mr. Yushimanti, I am appearing for the opposite party, BSNL.
Yes, sir. Tell us. Let the petitioner start.
My lordship, my learned senior is suffering from a bad serious fever. He is in
What is he suffering from?
fever.
Fever.
He is in
Who
hospital.
is your senior, sir?
Sorry, my lord. Yushimanti.
It is stated that counsel for the respondent is unwell. List on 2nd September.
Passed or matter, item number.
Obliged.
Sorry. No pass. Special list. Special list, fresh admission, item number 1, CRLMC 5108 of 2011.
I want to withdraw the case with permission to raise the point before the
All
last.
right. Permitting the petitioner to raise all the issues raised in the present petition at the appropriate stage of the trial court, the petition is disposed of. The interim order is vacated.
Special list, item number 2.
No instruction, your lords. No instructions. Interim order is vacated. All right. Copy of the order be sent. That's same thing.
Special list, item number 3.
May I please, your lordships? Lords, this present application has been filed for the quashing of an FIR. Lords, may I have the FIR?
Can you speak louder, sir? If you don't mind. Can you speak louder?
My lords. Lords, may I have the FIR at page number 11?
What is it under, sir? What is the provision of law under which it has been filed?
482, my lords.
Sorry, the FIR.
FIR.
What is the offense?
My lords, under section 47A of the Bihar and Orissa Excise Act, my lords. Seizure of country liquor, my lords.
All right.
Lords,
you can raise all these points, sir, at the appropriate stage.
Lords, I would like to submit one thing, lords. Basing on the statement of the driver, lords, this FIR has been lodged. The driver has made a statement that the shop from where he was supplied the liquor.
Some court will look into all that, sir. Some court, not this court, the appropriate court will look into it. Same order, permitting the petitioner to raise all the pleas at the appropriate stage. The petition is disposed of.
Special list, item number 4.
No instruction. No instructions, dismissed. Interim order is vacated.
Special list, item number 5.
May you please, your lordship, this case may be permitted to withdraw.
Oh, yeah, counsel permitting the petitioner to raise all the pleas, same thing.
Specialist for orders item number 6.
Lord, I don't think madam, it is the forest secretary, my lord, opposite party, on whom it is stated that notice has not gone. I think the central government is appearing for him. I don't think it is necessary. Similar matters has already been decided to be placed. A large number of cases on 29/7 by a judicial order of this honorable court, but because of the assignment has changed, it will probably go to Justice Pujari now. Your lords may dispense with that notice, my lord. The central government, Mr. Paddy was here, my lord. I don't see him. But the short point is whether 2006 impact notification will apply to productions cost
This is nothing to
prior
do
to
with
it.
What is this order to do, sir? You've handed over some Prabodh Mohanty order of Justice Mahapatra, A.K. Mahapatra. Has it anything to do with this case?
A similar matter, a large number of cases adjourned to 29/7.
All right. List on 29/7/2022 before the roster bench.
Before the appropriate bench.
All right, before the appropriate bench, along with criminal MC number.
A large number of cases.
127 of 2014. Then you say Mr. Mohanty Leonard, senior counsel, appearing to petitioner today states that
Opposite party
party number 2 is not a necessary party, is it?
Opposite party is necessary because annual notification will come into play, my lord.
Then
That is government of India, my lord. Instead of registered post, my lord, let me be allowed to serve a copy. I have already served a copy on the central government senior standing council.
all right, states that he will serve a copy of the petition on the senior standing council of the central government before the next stage. All right.
Special list for admission item number 7.
None appears. This is not possible. The interim order is vacated.
Special list item number 8.
The petition is dismissed as withdrawn. The interim order is vacated.
Special list item number 9.
May I please, lordship? It's a false case. A husband is the complainant. Allegation is that the wife and the daughter were abducted by the petitioner. But the case is otherwise, your lordship may kindly 164 statement. The husband was continuously meeting out torture. They wanted to escape. The daughter is a friend of Milord, the present petitioner. He only arranged a rented house for them. That is what the 164 statement as page 17 of the victim, both mother and daughter, they are there. Page 17 and 19. Both the victims, they have stated that because of the husband was torturing and we have not been abducted or kidnapped, we voluntarily left and stayed somewhere. It has been stayed, Milord, 2011 proceeding. And second thing, Milord, there is also a case against the husband by the wife for allegation and torture, 498A, that is annexure 5. It's a malicious proceeding. Milord, page 17 and 19, of course, that is the 164 statement of both the victims. The wife's statement, Gita Sahu, she says that I voluntarily left the house because of the torture meted out by the husband. And daughter also, minor daughter.
Unless there's this is a contested petition, I suppose. Who is appearing for the other side?
Yes.
Sir, unless there is an agreement or something,
yes,
or an affidavit of the informant, it's not possible to simply quash it, sir, like this, without contest.
The one entire proceeding, I think, is there. 164 statement I have filed, Milord.
No, I know. So there is, unfortunately, sir, no reply. There's nobody appearing, so this is a problem.
That's true.
Balaji Sahu was implicated as opposite party number 2. And I think at one stage he was represented, correct?
I don't know Milord, exactly. It's a 2011, but there is an interim order. So I don't think it's to be implemented as a pro forma party, Milord, because it's a police case now because the police was investigating. It's a complaint case, and that is also a counter case when the wife filed a torture case 498A.
Oh, she cannot be a pro forma party. She's a necessary party, not a pro forma party.
Yeah, he's a necessary party. Informant is not a pro forma.
In that event, your lordship may permit me and take.
Yes, I think so, sir. Permitting the petitioner to raise all pleas at the appropriate stage of the trial court, the petitioner is disposed of. The
No,
interim.
Milord, what I'm praying, let me implement this informant as a party. Your
No, he's been implemented, sir. He has been implemented. Notice went to him.
So, Milord, therefore, your lordship, if none appears, then your lordship may, he's not, maybe not interested. So, therefore, Milord, affidavit, your lordship may look at the record on the face of.
Sir, if he's not interested, he will not appear there also, sir. That's far better.
No, Milord, what I say, you are submit, Milord, your lordship may kindly look at page 70. That is the 164 statement when the.
Sir, all this has to be examined by some court. We'll have to give him a chance. So, because these are only handwritten statements, this will have to be, we will have to record the statement of these two in the court. Because this is after all only a handwritten statement. They'll have to record this in the court.
Both the victims say that we voluntarily left the house and we don't.
Correct, correct. They'll probably have to file an affidavit or appear and make that statement, sir. Then it will get over. Or
that's true, but if he doesn't turn up, Milord, then it's.
no, but even here for me to act, they will have to make some statements and affidavit. It's better you do it in that court itself, sir. Permitting the petitioner to have the victims produced before the alleged victims produced before the court for recording their statements. The petition is disposed of.
No, Milord, their statement has already been recorded 164.
No, before that is 164 is before the magistrate, sir.
Minor.
This is the trial court. You may have to take them there. They'll have to stand by those statements. All right.
Specialist item 10.
Hello, time for the OP number 2.
None appears for the petitioner. This was a non-prosecution. The interim order is vacated.
Specialist item 11.
No instruction.
No instructions dismissed. Interim order is vacated.
Specialist item 12.
None appears dismissed. Non-prosecution. Interim order is vacated.
Specialist item number 13.
The matter has been rendered infructuous.
Counsel the petitioner states the matter is infructuous. It is disposed of as such. The interim order is vacated.
Specialist item 14.
Liberty may be granted to or say all the parts.
All right. All the pleas raised. Petition, permitting them to raise all the pleas at the appropriate stage. Right. The interim order is vacated.
Item 15.
Lordship, item 15 also.
14 that is. Sorry.
Sorry, sir.
14 dismissed for non-prosecution. 15 is disorder.
Item number 16.
Same.
Sir, 16 also same. Oh.
Item number 17.
None appears dismissed non-prosecution. Interim order is vacated.
Item number 18. May I please, your lordship? Your lordship's kind permission. I'd like to draw your lordship's kind. The petitioner is facing a proceeding under section 307 IPC, where Milord, none of the Milord, the ingredients of 307 is attracted. Moreover, Milord, petitioner is implicated as he the highest holding the highest post of the Milord plant, and he was not present in the place of occurrence and no about that is attributed. And though Milord, the occurrence took place, while Milord, the nearby villagers with a grievance petition, they wanted to meet the Milord executive director, the present petitioner, and the president of the Milord, the plant, where the SP was present and the Milord sub-collector was present. The mob was Milord prevented, and then Milord, on the next day, when the mob was going to meet, that time they were prevented by the security guards. And Milord, the present petitioner neither present the spot, no overact as per the Milord allegation. It is clearly mentioned in the FIR that I may permit to place the English translation, Milord.
So there is no interim order here. What has happened?
Your lordship may kindly, as your lordship, this instruction was there too by the state government State Council, because 307 is not protected.
No, but no interim order here. What happened in the lower court?
Also, informant has not been made a party.
There has been no interim order passed in this petition in the last 10 years. None of the council is able to inform the court the current status of the case pending in the trial court. If such case is pending, the the petitioner is permitted to raise all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of.
Hopeless. Specialist item 19.
Pardon, my lord. My lord, item number 19, no instructions.
No instructions, dismissal non-constitutional.
Specialist item 20.
Interim order vacated. None appears, dismissal non-constitutional. Interim order vacated.
Specialist item 21.
None appears, dismissal non-constitutional. Interim order vacated.
Item 22.
None appears, dismissal non-constitutional. Interim order vacated.
Item 23.
23, lordship, no instruction.
No instructions, dismissal non-constitutional. Interim order vacated.
Item number 24.
My lord, pray for quashing of the criminal proceeding on the ground of compromise, your lordship. The both are major. They have married, your lordship, and are living happily, your lordship. Affidavits are there, marriage certificate also there, your lordship. Father has lodged the affair under section 363, 366. Later on, she knew that his daughter fled away with the petitioners, and they married at the mocks, and your lordship certificate is there, annexure.
The affidavit of the victim and the marriage certificate showing the marriage between the petitioner and the alleged victim are placed in record. There is no denial of these documents by the council of the state. Paragraph. Consequently,
the notarized marriage was.
No. Marriage annexure 3.
Khapra Code PS case number 4 of 2014 corresponding to GR case number 17 of 2014 pending the court of the SDGM Patnagarh. And all proceedings and orders consequent thereto are hereby quashed. The petition is disposed of.
Specialist item 25.
I am appearing for the opposite party number 2 complainant.
All right. None appears dismissal non-prosecution. Interim order.
Matter the little quarrel in
You are appealing the petitioner.
at the time.
Sorry.
Petitioners. At the time of Panchayat election, some little quarrel was between both parties, and already the amicable settle.
Where is that? Annexure 3.
Annexure.
I have no instruction. I have no instruction with regards to settlement. It is stage of affair. It filed.
No, you filed an affidavit. You are opposite party number 2. What do you say in your affidavit?
Initial and affidavit of filed denying the settlement.
Then that's okay, sir. Then you go back to the trial court then. Although the petitioner claims there has been settlement between the parties, opposite party number 2 has filed an affidavit denying it. Consequently, the court is not persuaded to interfere at this stage, permitting the petitioner to raise all the pleas raised in the present petition and reserving the right of the opposite party number 2 to oppose those contentions at the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated.
Specialist item 26.
My lord, item number 26, the petitioner does not want to press this application.
Counsel, the petitioner states it does not wish to press the petition. Dismiss is not pressed. The interim order is vacated.
Item 27.
None appears. Dismissal not prosecution.
Item 28.
Question for ground of compromise, my lord, affidavit there, my lord. The family dispute between two brothers. Belongs to one family.
Affidavits of respondents 2 and 3 have been filed, stating that the disputes have been compromised. The disputes have been settled through a compromise. Full stop. There is no denial of the said documents by the council of the state. Accordingly, the proceedings GR case number 1 of 2014 pending the court of the SDGM Kurda and all proceedings consequent thereto are hereby quashed. Petition is disposed of.
Item 29.
None appears dismissed on non-persecution. The interim order is vacated.
Item number 30.
May I please? The unfortunate case, your lordships, where my lords, the husband of the petitioner number 3 was shot dead. And she and her brothers have been implicated in this case because the marriage of the deceased with petitioner number 3 was not acceptable to the family members. Well, it's
So 201 is disappearance of evidence, sir.
yes, my lords.
What do they do?
302 is there.
Oh, 302 is there. Yes, because that's not even mentioned in the petition.
Not against the petitioners. The petitioners have been charge sheeted under 120B, 201, 216, read with 34.
So for screening evidence.
For screening evidence.
What have they done? According to the prosecution.
According to the prosecution, my lord, the prosecution story is that one lady accompanied by the deceased was walked
the final form.
Sorry, Mara?
Final form. For losses can prevail in the final form. 302 is there. Charge sheet, final form charge.
Annexure 1 is there. Annexure 1 is charge sheet.
Right.
My lords, the prosecution case is
yes,
that one lady was accompanied by the deceased was walking along the sea beach at Puri when she was accosted by 4 persons who started molesting her. And when the deceased intervened, one of the 4 persons whipped out a gun and shot him there. Now, my lords, thereafter the police has entangled the petitioner on the version of this lady who says that she had once heard the petitioner and her brothers saying that since the deceased had fought with the petitioner number 3, they had said that we would do away with his life. This is the only statement linking the petitioner to the incident in question.
No, but has that has that lady been examined in the trial?
No, she has not yet been examined.
So let her statement get recorded in the trial, sir. Only then we'll know this. At this stage, how can we adjudicate this?
The 161 statement, the investigation has been completed.
This is not the stage, sir. This is not the stage. It's a 302 matter. It will come up in the evidence, not in the 482s.
Well, to implicate me under section 122, 120B,
yes,
there has to be some meeting of mind with.
Anyway, they have a witness. They have a witness. So you demolish the witness, even at the stage of charge, you can do it. You have not even reached the stage of charge, sir.
They have been already charge sheeted.
Charge sheet is different.
Right.
Order claiming charge is not passed yet. Is it been passed? I don't think so.
I think it has been.
There is a stay.
There is a stay operating.
No, the split trial had proceeded.
Stay option.
Hey, maybe split trial down the
Only in 2014 there was a stay. This is not the stage, sir. Anyway, charge sheet was filed when?
Charge sheet immediately after the charge sheet.
Because it's the incident of 1999.
Yes,
17th August 1999.
My goodness.
That 21st
1999.
After 15 years, it's been stayed by this court.
Yes, but
It's extraordinary, sir.
because one of the grounds taken was the undue delay in getting with the trial.
Let the statement of the lady be recorded. You say permitting the petitioners to raise all the pleas available to them to be raised at the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated.
Your Lordship, grant me leave to move the court after the lady's statement is recorded.
That you will anyway have, sir. That you will anyway have. Right.
Specialist item 31.
31, I am appearing for the complainant of number 2 Miller.
All right. None appears dismissed, non-prosecution. The interim order is vacated.
Specialist item 32.
Item 32 on behalf of Mr. Mahapatra. Let the matter will be taken up next week, my lord.
No, tell us what the matter is.
Mr. Mahapatra now is state counsel, my lord. Mr. Mahapatra is now representing state. He'll engage somebody else.
You are there, sir. You should study the matter.
No, my lord. I do not have the power, my lord.
No, but you can't just come before the court without papers, not knowing what the matter is. Please.
A humble request, my lord. Just next week,
We'll just see what the matter is. 1 minute.
Kidnapping of a girl, 363, 366A.
All right.
They do 34 of the Indian Manual. But the FR has been registered.
Which matter is this?
32.
Item 32, SS.
32 3, Ranjit Kausalya.
Ranjit Kausalya.
Ranjit Kausalya is something else, sir. Some marriage photo and all is there. Oh,
Why?
376, 366A. But there's no statement of the opposite side.
None is appearing.
Is this the same Mr. Mahapatra appears in income tax matters?
No, sir, as it appears,
Is he an income tax counsel now? Who has sent you, sir?
My lord, SS Siddharth Shankar Mahapatra.
Is he appearing in?
Yes, my lord. He is now.
No. He's an income tax counsel means it's central government. It has nothing to do with state government.
And he's also AC.
He's also standing on.
Yes, my lord.
It is stated that the counsel to petitioner is now a state counsel, and alternative arrangements are being made. List on 2nd September.
Interim order to my lord.
Sir, nothing is going to happen. You're not even aware. You don't even have the paper book. You've only been asked to go and say adjourn. If you had the paper book, if you're prepared to argue, I'll extend interim order. If you're just going to stand up without any instruction, without any papers, not interested.
Item 33.
Yes. Certainly not, sir. You have to, you have the paper book of the matter.
No.
The day somebody sends you like this to the court, saying go to the Chief Justice Court, just ask for an adjournment. And you rush into the court, no papers, no instruction, just stand up and say, sir, adjourn. You will not get orders. If you say, sir, if you want me to argue for continuation interim order, please give me a paper book, let me go through it. Then we really appreciate. You've seized the opportunity. Seize an opportunity, sir. You're getting an opportunity to appear in a high court, argue before the Chief Justice, correct? You should make good use of that opportunity. Not stand up and say, sir, no papers, nothing. I don't even know what the matter is. You're fortunate we're not dismissing the matter. Yes.
The matter will next week, my lord, next week.
Have you heard what item is passed? Even that was not heard.
2nd September.
Follow up the next part.
Item 33.
Give you a list.
Item 33.
None appears dismissed on opposition.
Specialist item 34.
None appears dismissed on opposition.
Specialist item number 35.
35 will also no instruction.
No instructions. Dismissed. Interim orders of fate and all these matters.
Specialist item 36. Item 36.
None appears dismissed on opposition.
Specialist item 37.
37. The petitioners counsel joined in the state panel. Today morning, I received the Vakalatnama. I pray for a week time, matter has been settled. And friend Mr. Misra has appeared. I have also took instructions from him today morning. He also said the matter has been settled. I'll file the affidavit by next week.
All right. The request to counsel the petitioner list on 29th. Right.
Specialist item 38.
Some filed this case for questioning the FIR matter on the ground that both the parties are settled their dispute. OPR already appear.
Copy number 2.
307.
Yes, ma'am.
Affidavits have been filed.
Affidavit filed, my lord. Both the parties have also appeared on the earlier occasion. Both the parties have also appeared.
All right. By both the injured parties, stating that they've settled the disputes and do not wish to proceed with the matter further. This is not disputed by counsel of the state. Accordingly, ST number 83 of 273 of 2013, arising out of Astaranga PS case number 38 of 2011, corresponding to GR case number 282 of 2011, pending the court of the Assistant Sessions Judge, Nimapada, and all proceedings consequent thereto hereby quashed.
37 interim order is there, pardon, my lord. 37 interim order was there.
Nothing will happen, sir. We'll see what happens in 1 week. If the state is so efficient, I'll be very impressed. Yes.
Hold on.
Item 39. My lord, here is an interesting case that a complaint case is filed just counter blast to my complaint under section 138 NI Act. I have filed a complaint Annexure 3, my lord, page 9, in which I have alleged that the check of the accused has been degenerate. So I filed that complaint case.
What happened in that complaint case?
That is still continuing. It is.
So if that is continuing, let it also continue.
Well, it is just filed as a counter blast to my complaint.
Sir, unless there is a compromise between the two of you, you file some settlement here.
No, here is an judgment.
This will become a disputed question, sir.
Here is an judgment of the Supreme Court.
Sir, cases first make out a case and facts.
Just befitting to my case.
So first make out a case and facts, sir, then we'll read the judgment. We will certainly read the judgment. You make out a case and facts first.
This complaint in which I have challenged the order that has been filed under some sections of IPC.
So please tell us sections.
406, 420, 468, 294, 506 IPC.
Very good.
And it is alleged that the check which was in question, the check which is challenged, that was given to him. That was given to the petitioner as a security. Both the cases have no, just as a counter blast to get rid of my complaint under section 138. This complaint has been filed.
What is the date of your complaint?
Pardon?
What was the date of your complaint?
The date of my complaint is April 12.
No date in April.
Yes. That is on filing 25 April 12.
And then?
And cognizance has been taken in my case on 26th July 12. And this complaint has been filed on 8th May 2013. After notice has been served and the NVW has been issued, and he was apprehended and released on 205 dispensing with the personal attendance. This complaint petition has been filed.
So this notice has not come back.
Much earlier notice has been issued to.
Issuing is one thing, sir. Serving the notice is another. All right. Notice being issued is one thing. Notice being served is another thing.
Unfortunately.
Notice has not yet been served.
My lord, Notice was issued on 7/8/14.
I see.
Order was passed, issue notice to the sole opposite party by registered post.
So how does one examine this correctness or not of this? It's difficult.
Well, this judgment of the apex court is just befitting to my case.
There also he was ex parte.
Pardon?
In that case also he was ex parte.
Justice Deepak Mishra and Prapal Sivapan.
I did ask who gave the judgment, sir. I want to know on the facts of that case, the opposite party had been set ex parte.
It is stated after some complaint.
It's not possible for the court to investigate these facts here.
Pardon?
It's not possible for this court to investigate these facts here, sir.
Hey,
You say permitting the petitioner to urge all the pleas raised in the present petition.
In that case also, as a counterblast to the.
You can apply for discharge, sir. You cite this case there and apply for discharge at the appropriate stage before the trial court. The petition is disposed of interim orders vacated.
Specialist item 40.
Interim order, what about interim order?
Yes.
Item number 40.
I am for the informant, opposite party.
Sorry?
I am for the informant, opposite party.
I see. None appears dismissed for non-prosecution. Interim orders vacated.
Specialist item 41.
41, no instruction. No instructions dismissed. Interim orders vacated.
Specialist item 42.
Dismisses withdrawn. Interim orders vacated.
Specialist item 43.
None appears dismissed for non-prosecution.
Item 44.
44, my lord. My lord, wide order dated 39/2014. My lord, 2014. This honorable court has been pleased to direct for recording for 164 statement of the victims, opposite party number 3. Accordingly, that has been done. This is the certified copy where it is found that she fell in love with the petition number 1 and they are leading their life, marital life till date, my lord.
What is that?
My lord,
what are you having in your hand?
My 164 statement of the victim girl. Of course, it is in Udia language.
See that copy.
Last one. Major girl fell in love with the present petition number 1. Now they are leading their life, happy conjugal life, and father filed a case regarding with an allegation that the petition number 1 and the other petitioners have kidnapped the her girl. Victim.
Yes. All right. You see, the counsel petitioner has produced before the court copy of the statement of opposite party number 3.
My lord, this.
Keep it on record, stating that she is now married to the petitioner of her own will and is living happily. The said statement has been produced by counsel for the state and has been confirmed to be true. That you to matter. Just keep it on record. The said statement is taken on record. That you have to matter. GR case number 1145/2014 arising out of Bienpur PS case number 184. Dated 9/9/2014 pending the court of SDJM Berampur and all proceedings consequent thereto hereby quashed. The petition is disposed of.
Okay. Specialist item 45.
45, may I please, your lordship? My lord, the petitioner number 1 is the victim and the petitioner number 2 is the accused. They both married each other, my lord. The father of the victim, my lord, petitioner number 1, lodged the affair, my lord, alleging, my lord, 363, my lord. In the meantime, both the petitioners, my lord, lived together and they having, my lord, their children, my lord.
Where is that? Where is the proof of that, sir?
My lord, that proof, my lord, your lordship, permit me to place, my
At the
lord.
request of counsel, the petition list. When do you want it?
My lord, within next week, my lord, I will produce.
29th. All right.
My lord.
Specialist item 46.
None appears. This is not prosecution.
Item 47.
May I please, your lordship, passing of the proceeding, the petitioner and the OP number 3 married to each other and living happily. This is the certified copy of the 164 statement. Due to some disturbance between the daughter OP3 and the OP2, FR was registered. They were living happily, my lord, as per the 164 statement.
Dursila Gaud.
My lord.
Yes, my lord.
All right. Counsel petitioner produces a copy of the section 164 statement of the opposite party number 3, stating that she is now married to the petitioner and is living happily. The counsel of the state has confirmed the said statement for perusal, which is taken on record. Paragraph. As a result, it is taken the prayer clause, Kharia PS case number so and so, all that are hereby quashed. And all proceedings consequent thereto are hereby quashed.
Item 48.
None appears. This is non-prosecution. Interim order is vacated.
Specialist item 49.
None appears. This is non-prosecution. Interim order vacated.
Item number 50.
None appears. This is non-prosecution. Interim order vacated.
Item 51.
None appears. This is non-prosecution. Interim order is vacated.
Item 52.
May I please? Challenging the cognizance order, madam, on the ground of jurisdiction, madam. The present petitioner, madam, one is the husband and the other are in-laws, madam. And petition number 2 is the wife. My lord, the allegation, he has filed a complaint case at Rampur. Now, the entire allegation, the marriage solemnized at the petitioner's house, my lord, that is as Mundamari. And after marriage, they both went to Delhi and resided some days, and after torture, the complainer has stated that the present petitioner number 1 has tortured, for which he returned back to his village and resided at Risida, my lord. At your lordship may kind of a glance to the page annex to 1, page 8.
Sir, all these are disputed questions. It's not a settling matter.
My lord, so far as jurisdiction is concerned, my lord, the Lord and JMFC has no jurisdiction to entertain this bare perusal of the complaint petition, and I have annexed the deposition, my lord, to 202 inquiry, my lord. He has stated that all the allegation him at his matrimonial house at Mundamuri in Aska, my lord, and Delhi. Not a single incident she has stated at M. Rampur, my lord. So M. Rampur has no jurisdiction. She temporarily reside at father's house, who is situated at, my lord, Rampur at Kalahandi. For in this regard, my lord, your lordship, Honorable Supreme Court has.
First, let's go factually, sir. By counter affidavit, she denies this. Where have you said in the petition that about jurisdiction?
My
Which
lord,
paragraph?
my lord, 7, my lord.
Para 7.
My lord,
Let's
6
see
and
that.
7.
1 minute.
6 and 7.
Six is of some bail bond or something. What is this?
Page 4, my lord.
What read page
My
8.
lord, that it is respectfully submitted that the marriage between the informant and the petitioner was held at the
What is
residence.
this? Which item is it?
My lord, 52.
52.
6003 of 2014.
51 is over. Yes.
My lord, your lordship can have a glance to page 6 and 7.
So, but what about have you served? Notice is gone or not?
Yes, my lord. So,
Have they all been served?
appear, my lord.
Who's appearing?
Jane Honda. Jane Honda.
There are so many events not happening at Delhi, sir. No, come to the complaint, page 9. FIR or complaint, whatever.
My lord, that is a complaint case.
So the first page itself, many events not happening in Delhi.
Delhi and in my lord, in the under the jurisdiction of ASCA, my lord.
No. Just come to the first page of the complaint.
Page 8, my lord. Annexure 1.
It's 9.
9, my lord. So he has stated that he has lost the FIR in ASCA police station, but police have not taken any action against the accused person.
You're not mentioning the place, sir. Just read that second paragraph. Dowry given in some
At the
place.
time of marriage, demanded.
Where did the marriage take place?
My lord, marriage took place in the year.
No.
No,
I didn't say the
29.
year, sir. Where did the marriage take place?
20 at my lord, at Mundamuri, in the district of Ganjam, my lord. I have written, my lord. Paragraph 2, my lord. And he has also stated that her marriage was solemnly at Mundamuri.
No. Where is the wife residing now?
Residing at my lord.
Kalahandi.
My lord, Kolahandi.
So why can't she file it there?
No, he has, my lord, in this particular district, my lord.
Presently residing at Risida Rampur,
Right.
district Kalahandi.
Your lordship, I can have a glance to this. By
Have they been served the opposite parties? Has the opposite party? You just pass it over once.
my lord.
Specialist item 53.
Next, my lord, the victim has filed a petition not to proceed with the case under Annexure 3, my lord, which has been rejected by the court below, my lord, under Annexure 4, stating that Section 320 of CRPC is not permitted to compound the offence, my lord. The victim has herself filed a petition not to proceed with the case.
Why is she not filing an affidavit here?
My lord, notice has already been issued.
No, has notice been served? Notice has been received back. She's not appearing here. You say an application was filed by the opposite party number 2 before the trial court, stating that she did not wish to proceed with the matter. So, however, that application got rejected by the order dated 9 June 2014 on the ground that the power to compound the offence under Section 320 of CRPC does not exist. Paragraph. Before this court, in the present petition, notice was served on the opposite party number 2, and despite service, she has not appeared. Full stop. There is no denial of the fact that she has herself filed an application stating that she is married
Para 3, your lordship.
Yeah. And does not wish to. She's married somebody else.
Yes, your lordship. The brother of the present petitioner.
Sorry?
The brother of the present petitioner.
She's married the brother of the present petitioner, does not wish to pursue the petition any longer, the complaint any longer. Full stop. These facts are not denied by counsel of the state, despite notice having been issued long ago. That clear the matter. Proceedings in CT case number 190 of 2009, corresponding to Tigriya PS case number 43 of 2009. The order taking cognizance dated 14 July 2009 of the SDJ Attagad, and the case, aforementioned case, pending in the court of the JMFC Tigriya, I hereby quashed.
Item 54.
Not the order of cognizance under challenge, that is the order dated 9 May of 2006, my lord. Not the offense under section 354, 452 and 323, 427, my lord. The informants are also entered into an appearance, my lord. And the petitioners are poor persons, and the allegation is very petty allegation, my lord. They are collecting some firewood from the courtyard of the informant, and the allegation is outcome of that, my lord. And the individual has been stayed, my lord, in this case.
Sir, informant is not a party here. Oh, the informant has been served.
But he appeared.
Is there a compromise between the parties?
Pardon, my lord.
Is there a compromise between the parties?
Yes, my lord.
Where is that?
Para 4 millets, they just make an averment, but there is no.
There is an
There has to
affidavit.
be, there has to be an affidavit or a joint petition.
Yes, my
something.
lord, I have not contacted with them. Let it be next week. I will.
At the request of counsel, the petitioner list next week, 29th.
Oblige.
Item 55.
None appears dismissal of also. Interim order.
Specialist item 56.
Lordship may permit it to withdraw, Lordship.
Withdrawn, dismisses, withdrawn. Interim order.
I am appearing on behalf of OP number 2, your Lordship.
All right.
Specialist item 57.
My lord, question of the criminal proceeding, that offense relating to my lord 498 IPC, my lord, and on the basis of my lord compromise petition, my lord, already my lord, diverse my lord granted under section 13B, my lord, and that the annex of 3, page 21B, my lord, that mentioned.
All right. The grant of decree of divorce under section 13B, where is that?
Annex of 3, page 21, para B, my lord, that we mentioned.
Petition. Annexure 3 is the 13B petition.
That petition, my lord, that is signature, their signature, and I admitted that she wants to withdraw the my lord.
No, where is the order of the court, sir?
Court order, my lord, that next week, my lord, I produce any day, lord.
Counsel the petitioners at the request of consultation list on 29th.
Specialist item 58.
Actual mode, my lords. May I please your lordship. I am SD Das, my lords. I am on
Yes.
actual court.
Yes.
My lords, in view of the judgment of this honorable court, this is a case initiated under the Environment Protection Act 1986. Section 16 provides the company and both the company and director to be made parties, offences by companies. And I have sent the copies of the judgments of this honorable court. 2 judgments I have sent today. Could my lord get it at sent?
Yes.
First judgment, page 23, last para, my lord. Therefore, when it was brought to the notice of this court by petitioners by filing this application without arraigning the company. And
Anita Hada. Yeah, it's well settled,
yes.
sir.
Yes, my lord. So in that view of the matter, it has been quashed, but liberty has been given to file fresh complaint in accordance with law if not necessary. The second judgment
All right.
following that is that.
All right.
Here, company is not a party, annexure 1. Only
The
directors.
present petition seeks the quashing of complaint case 2CCC number 17 of 2014 pending the court of the JMC Jashpur Road, Jashpur, which has been lodged only against the directors of the company.
And one of them is dead now. We will also kindly also observe.
And not the company itself. Stop. One of the persons against whom a complaint was filed, one of the directors is no more now. Stop. Present 2 directors. The present 2 petitioners are the directors of Director and Vice President bracket mines respectively of Baleshwar Alloys Limited, earlier known as Ispat Alloys Limited, which has not made a party to the complaint. Paragraph. In view of the judgment of the Supreme Court in Anita Hada versus.
I think it is 2012.
Not for the
5
travels and tours 2012-52 OCR bracket SC bracket 254,
It is 12.
which has been
2012
followed by this
5
court
SC.
in its judgment dated 26th August 2019 in criminal MC 1923 of 2018 bracket Orissa Mining Corporation of the State of Orissa, holding that in the absence of making the company itself a party, it's not open to the complainant to proceed only against the directors. The aforementioned complaint case 2CCC of 17 of 2014 and all proceedings consequent thereto hereby quashed. Petition is disposed of. The
Obliged.
copy is ordered to be sent to the concerned court forthwith.
Obliged.
Specialist item 59.
None of this is not possible. Interim order is vacated.
Item 60.
Still also have no instruction regarding status of the case. All right, no instructions dismissed, no possible. Interim order is vacated.
61.
My lord, item 61, there's no instructions.
No instructions dismissed, no possible. Interim order is vacated.
Item 62.
None appears dismissed, no possible. Interim order is vacated.
Item number 63.
My lord, I am from the petitioner. Praying to was the order dated 12th November 2014 of the SDGM Bhubaneswar in respect to 1CC case number 2275 of 2012. In view of the judgment, AAR 14.
What is the offense? What is the prayer? What are the facts?
Yes, sir.
First, you say all that and then we come to judgment.
Yes, sir. Yes, sir. Yes, sir. Yes, my lord.
1CC case 2275 of 2012.
My lord.
This is 138.
Yes, sir.
Yes.
Yes, my lord. Yes, my lord.
Have you paid the informant the entire amount or you have not?
Miss, the reason is that checks are issued in the
So Minex India is partnership from. Is there a compromise with Minex India?
no, my lord, no compromise. The checks are issued in the West Bengal in the Haldia branch, but he has placed the check at the Bhubaneswar. In the meantime, of course, the law has been changed, the jurisdiction point. Recent time, the Droi bank, where the bank was, where the checks were issued, is to be presented.
Anyway, so now you can urge all the points at the appropriate stage. You say permitting the petitioner to urge all the points raised here at the appropriate stage with the trial court. The petition is disposed of. The interim order is vacated.
My lord, ultimately it would be infractious because in the meantime.
Then all the better, sir. Why should we worry here now? Yes.
Item 64.
None appears dismissed, not possible. Interim order is vacated.
Specialist item 65.
My lord, trial is over. Kindly permitted to withdraw, my lord.
Counsel petition seeks leave to withdraw the petition. Dismiss is withdrawn. Interim order is vacated.
Item 66.
My lord, on behalf of Mr. Mahanti, due to his death of his elder mother, kindly taken up next week.
All right, at the request of counsel petitioner list 29.
Specialist item 67.
None appears dismissed, not possible.
Item 68.
Item 68 to 76, my lord, no instruction.
No instructions.
I am appearing for the opposite party.
All right.
Commission.
All right.
My lord.
68 to 76. Specialist item 77.
Withdrawn. Interim order is vacated.
Specialist item 78.
None appears dismissed, not possible. Interim order is vacated.
Item 79.
May I please, your lordship? My lord, last occasion, this honorable court has directed to obtain 164 statement of the victim, my lord.
You have it.
My lord,
Please. Yes, my lord. I have the 164.
So that confirms it.
Yes, my lord, where she has stated, the victim has stated that the petitioner and the victim is staying as husband and wife, and they have children also, my lord.
All right. Counsel for the state confirms that the statement of the victim under section 164 CRPC confirms that she and the petitioner are married and they have a child
Yes, my lord.
and have a child and are staying happily with each other. In that view of the matter, the Colliery previous case number 10 of 2015 corresponding to GR case number 29 of 2015 pending the court of the SDGM Talcher and all proceedings consequent that were hereby quashed. The petition is disposed of.
Obliged, my lord.
Specialist item 80.
Your lordship, regarding this matter, will raise all the contentions.
All right, permitting the petitioner to raise all the contentions raised here in the appropriate stage. The petition is disposed of. Interim order is vacated.
One pass.
Obliged, your lordship.
Specialist fast over matter item 52.
Right.
Nobody is appearing.
No, madam.
Despite service of notice on opposite party number 2 and despite his being present, represented by Mr. J.N. Banda, learned counsel, none is appearing in his behalf today, despite a passover. Full stop. The principal contention of the petitioner is that the petitioner and opposite party number 2 resided last together at Delhi and earlier were residing at Mundamarai district Ganjam. And yet the complaint has been filed in the court of the JMFC M. Rampur Kalahandi. Full stop. It is pointed out that there is nothing in the complaint which indicates that any part of the cause of action arose within the court, within the jurisdiction of the JMFC at Kalahandi. Full stop. Indeed, a perusal of the complaint does not show that any part of the cause of action arose within the jurisdiction of that court. Full stop. It only appears that since the complainant and her parents are residing within the jurisdiction of that court, they filed the complaint there. Full stop. Without examining this aspect of the matter, the JMFC has proceeded to issue the order dated 26 July 2014, taking cognizance of the offences in ICC number 27 of 2013 against the petitioner. Full stop. Paragraph. That view of the matter, the said ICC 27 of 2013 and the order dated 26 July 2014 are hereby quashed. Of the JMFC M. Rampur are hereby quashed. The petition is disposed of. Yes, sir. Tell us.
Your Lordship has seen, I have filed a detailed counter affidavit
Yes.
on behalf of the company. That means the petitioner in all those cases, and the reference has been made in respect of the subject matter of all those cases. But here, I just preliminarily, before your Lordship starts, not the property was sold. That took through court, through auction, by virtue of orders of the court.
No, but tell me, first of all, why should it go before a full bench?
But I don't know that full bench and that too.
There is an order passed by the Chief Justice A.K. Goel and Secretary author.
Can see the order dated 8/5/2004.
The matter is,
Yeah.
bench.
See, normally a matter is referred to a larger bench if there's a conflict of opinion of two coordinate benches.
Nothing like.
You see, sir, see that order. I see order dated. Sir, order dated 8th May 2014.
Yeah, I know seriousness and I don't think that is a ground, sir, because we have properties of much higher value also before regular benches.
Your lordship can say order dated 2/5/2014 also.
Right.
There is another order passed by another division bench.
Right.
That is why it has been referred to, it has been decided to be heard by a full bench. It is stated by the Lord Government Advocate that the ownership of the land in question has been changed in pursuance of the order of this court in WPC number so and so.
But that's not the ground on which they're referring to a larger bench.
Yes, that is not the ground to refer the matter.
They're simply saying because if it's a public land of value of more than 150 crores.
Yes.
But that's not a ground for referring to a larger bench. We can put it again before the roster bench, sir.
Yes, sir. Yes, sir. It
All right. The code is of the considered view. This larger bench is of the considered view that the present petition can be heard, will be heard by the regular bench and need not be referred to a larger bench of 3 judges. Since there is no conflict of views between decisions of coordinate benches. That we have the matter list before the roster bench. On. When do you want it, sir?
Lordship may kindly give some time. I have prepared I have given the date chart, I have given the note and the result. Your Lordship will fix it to some other date, convenient date.
The amicus curiae is now somebody else? Because earlier I think.
Amicus curiae is no more.
That's what. Let the roster bench appoint the amicus curiae.
Yes.
All right. 29th August.
29th August.
Right.
What's it?
All right. Well, all right. 29th August. Well.
And the interim order is there, so that is to continue.
All right. The interim order will
to
continue.
continue.
Correct. Interim order to continue. Right.
Item number 2. Item number 2, my lords. Your lordship, by a detailed referral order, by order dated 31/3/2022.
Yes.
Doubted the interpretation of section 10 of the Orissa Entity Tax Act, my lords,
Correct.
as was there in the judgment of Judge Ispat in para 12, my lords.
Correct.
And your lordship have also expressed my lord's view that even though my lords reassessment provision of section 43 of the OVAT Act and 10 of the OET Act are differently worded, but so far as genesis of considered, so far as self-assessment is concerned, your lordship said that 9(2) of the Entity Tax Act provides for acceptance in the same manner as 39 of the Odisha Value Added Tax Act. So therefore, your lordship wanted that it needs reconsideration. In the meantime, my lord's Keshav Gokai's judgment has now been affirmed by the Honorable Appellate Court.
Correct.
So in this, I have given points for consideration, synopsis of relevant provisions,
Right.
and comparable provisions of OET Act and OVAT Act. Your lordship will find several provisions below.
Mr. Sahu,
My lords.
that SLP.
SLP is pending, still pending.
SLP against Keshav Automobiles is dismissed.
SLP dismissed, my lord.
My lord's interpretation has been accepted by the Supreme Court.
Your lordship judgment is affirmed now.
Right.
Yes, in the I have stated in that submission, points of submission, your lordship will find
Yes.
detailed chart below.
Right.
My lordship will find section 9(2) below.
Yes.
9(2) is perimetria with section 39(2) of the Orissa Value Added Tax Act.
Right.
So in order that self-assessment to be accepted and complete below,
Right.
because not only section 9(2), I have also referred to rule 15, and unfortunately the counter which my department has filed, they have not at all referred to rule 15, and rule 15 below is the relevant provision
which provides for detailed provisions and the manner of self-assessment. Entire, all details are there. And rule 15, 1, 2, 3, 4, 5. I have also mentioned below the sub-clauses of sub-rule of rule 15, which are relevant. And that is in the same manner as rule 48 of the Orissa value-added tax rules below.
Right.
So therefore, in order that self-assessment is to be made, Millards, the manner prescribed under the rules, Millards, the manner, same manner as that of rule 48, Millards, rule 58 prescribes detailed procedure. And only after compliance of rule 15 2 Millards, then only Millards, and if that procedure, because acceptance is not a mental faculty, it must be reflected, so that if when challenged Millards, the opinion authority or Millards, when judicial scrutiny is directed by this, or your lordship will have occasion to know whether or not self-assessment is complete or not. Because the other day also, with the bar was addressing for also because the income tax pattern they are following, they make a endorsement stamp. SSC is assessed under section 143(1) of the Income Tax Act on total income of so and so. There must be some mechanism. And they have taken a stand. Now that the department is adopting this software, because returns are filed online, because had it been so, you could have made some palatable amendment under this provision so as to say that yes, acceptance henceforth will be done by this way, not by that way. Because the rules are there, section provision, legislative provision is very much there. So therefore, your lordship categorically in case of automobile case said that there must be acceptance bills. Unless there is acceptance bills, unless it is accepted, this cannot be complete. And unless it is complete, you can't invoke section 43 in the same manner bills. We are not on the different words enlisted under section 10 and 43. Your lordship doubting interpretation of para 12 in relation to judgment wanted to verify that whether acceptance, even if there's separation, whatever reassessment provision is there, but for the purpose of completion of self-assessment, that's over there, 9(2), my lords have verified and found tri-FSI is akin to 1339(2) of the Odisha Value-Added Tax Act. And also belongs Rule 48 of the Odisha Value-Added Tax Rules belongs, providing detailed procedure belongs for reassessment. It also akin to Rule 15 of the Odisha Entity Tax Rules belongs. So reconciling these two belongs, your lordship will find that unless the manner is followed, there cannot be completion of self-assessment. That you cannot say that merely because you have filed a return that will be treated as self-assessed return. Had it been so, there is no requirement of putting so much of provisions in 15(1) and 15(1), 2, 3, 4, and 5. This stands obvious belongs. That is not the case belongs. So legislature has in mind, including 9(2) and delegated legislation by the state government in exchange of power and 34 of the rules belongs. And rule 15 so 15 detailed procedure. So acceptance is a substantive provision, and that must be followed by the assessing officer. And one more submission I would like to make, because that precedes with scrutiny of every return. The language is every return is to be scrutinized by the assessing officer. Such a provision was there under section 38 of the Orissa Value-Added Tax Act. And because from the bar bills, earlier we have argued section 7, 10, and 11 of the Orissa Entity Tax Rules bills provides the similar procedure. That each and every return, language like this, each and every return filed by SSC is to be scrutinized by the assessing officer. And in course of scrutiny, if anything is found wrong, that will be intimated. Then after intimation, the SSC has to rectify. If it is not rectified after several opportunities, then that will refer to audit bills. So therefore, it contains several procedures bills. So therefore, had the scrutiny procedure and bills the procedure envisaged under self-assessment, these are analogous provisions not been there, and these are all empty formality bills, then probably that could not have been possible bills on your lordship as that very clearly mentioned in the referral order itself. My lordship kindly see para 4 bills. Yes. Yes, your lordship have said, nevertheless, I am reading those 5 lines from the bottom. Nevertheless, section 9(2) of the OET Act, which pertains to self-assessment and is a counterpart of section 39 of the OET Act, does contemplate acceptance of the return filed by way of self-assessment. Right, your lordship, after considering the provisions of,
I think after case for automobiles, there's nothing.
Exactly.
Great respect to my Lawrence Senior, all these arguments may not be required just now before this bench for argument, your lordship, because in case of automobiles, your lordship has already interpreted and Honorable Supreme Court has already confirmed. So I may not have any counter argument to the argument of my Lawrence Senior.
All right.
Now, your lordship, what the issue here is that here your lordship has interpreted in 2 ways. 2 interpretations, 2 provisions, your lordship.
One is 39(2),
Right.
another is section 43.
Right.
Here, let's see, section 39(2), an insertion has been made with effect from 1/10/2015. That insertion is that deemed assessment has been inserted, and whether it is prospective or retrospective, your lordship has already decided it is prospective.
Correct.
So, your lordship, that interpretation cannot be made prior to 1/10/2015. Now, your lordship, section 43, your lordship, so far the section 43 interpretation, your lordship.
Yes.
Section 43, your lordship has interpreted, and the provision is very clear.
Right.
Subject after completion of the assessment under section 39, 40, 42, 44, only the assessment section 43 can be done.
Correct.
Now, your lordship, section 9291
Yes.
of the Entity Tax Act is the parametric provision
For 39.
39 to your lordship.
Correct.
Your lordship has already stated in that paragraph 4 that section 40, section 10 cannot be a parametric provision so far as the section 43, your lordship. Why, your lordship? Because in section 43, there is restriction, prohibition is there, restriction is there, which is not in clear language, which is not the restriction in section 10. So,
Correct.
for better clearance, your lordship, I may be permitted to just reproduce section 10, your lordship.
All right.
Section 43 as well as section 10.
All right.
Now, your lordship, the question here is that, so far as Archer Ispat case is that, your lordship, only consideration has been made so far as the section 9(1) is concerned. So, I am not on section 9(1).
Right.
Because after your lordship's interpretation, since 9(1) is the parameter prior to amendment 1/10/2015 as per 39(2). So there cannot be any argument because that is parameter. So on this respect, so far as Archer is not, your lordship may consider that it is not a good law. Now, your lordship, so far as whether its impact is on section 10 assessment or not, your lordship may consider. Now, your lordship may kindly turn to section 10, where for any reason or any of the scheduled goods, your lordship, I'm sorry, your lordship may kindly turn to section 43 first. Why, your lordship? Because 43 judgment your lordship has interpreted. So, your lordship first kindly turn to 43 of the Orissa
OVAT Act.
Your lordship.
1 minute, 1 minute.
Yes.
Yes.
Prior to amendment, your lordship, 1/10/2015, prior to amendment.
Right.
Yes.
43(1), where after a dealer is assessed under section 39, 40, 42, or 44 for any tax period, the assessing authority on the basis of any information in his possession is of the opinion that whole or any part of the turnover of the dealer in respect of such tax period or periods escaped, under assessed, been assessed, or so and so, so and so, so and so. So my respectful submission before your lordship is that so far as that restriction that only after completion of section 39, 40, 42, 44. Now your lordship may kindly turn to section 10.
Yes.
Section 10(1), where for any reason, all or any of the scheduled goods bought by a dealer has escaped assessment of tax, or where value of all or any of the scheduled goods has been underassessed, or any deduction has been allowed wrongly, the assessing authority on the basis of income may order from the end of the year, 7 years, within years to issue notice. So now your lordship, so far as that restriction, whether after completion of section 9(1) or section 9(c), why your lordship, the legislature intention is very clear. Why your lordship? Because section 9(c) is the audit assessment. 9(1) is the self-assessment. I will not touch that provision, your lordship, because your lordship is very clear. So for section 9(c) is the audit assessment, your lordship. And each and every year, there is no mandatory audit. Your lordship, the audit assessment and your lordship, law is very well settled that even any third case report, any AG objection, or any mistake is there. So then how can that will be adjudicated? Because the assessing officer cannot go beyond the area. If 9(c) audit assessment will be there, then assessing officer has to do only basing on the area, basing on the books of accounts, your lordship. So suppose there is no assessment 9(1), your lordship, it is accepted that acceptance is not there and 9(c) is not there. Then suppose the third case report is arrived.
But there is other provisions for that.
No provision is there. No provision is there, your lordship.
No, then you have to provide for that in the statute. Because it's a taxing statute.
Why my submission?
It's a taxing statute. So if you think thought of another new situation now, which you say there is no provision, then that prevents you from providing for it.
Why I'm submitting this? Why I'm submitting this? For this reason, maybe, Your Lordship, there is no restriction, there is no prohibition in section 10, Your Lordship. So only that can I submit, because this 992 is the parameter provision of so far as 39.
The word used is escaped assessment.
Exactly.
Your
Assessment.
Lordship,
Assessment.
Your Lordship, but the prohibition is not there.
No.
Your Lordship, what is the difference in between 10 and 33, Your Lordship? But then why 43? It has been clearly inserted that after completion of 39, 40, 42, 44, assessment can be done, no, Your Lordship.
No, but here again has escaped assessment of tax or where the value or any of the scheduled goods has been under assessed.
Your Lordship,
This is whole, there's something that So you have to read it not disjunctively. If you read it as a full sentence, Your Lordship shows that the assessing authority has done something where he has not noticed something, he has under assessed, or he has wrongly assessed something that has been done by the assessing authority.
I can understand.
That's the
only my argument is restricted.
Yes.
So only that can be my argument.
Yes.
There is no prohibition here.
No, that's no prohibition. You see, very clear taxing statutes. If you think something has to be taxed, like this audit is a report.
Why, Your Lordship? Why, Your Lordship? Previously, there was OST Act.
Yes.
In the OST Act, the same language was there.
Yes.
The same language was there.
Yes.
This language.
Yes.
One bad act has been introduced.
Some better protection.
Then Your Lordship, why? A question comes to my mind. Why it has been inserted?
Why a question comes to our mind? What prevents you from amending?
Your Lordship is absolutely right. But Your Lordship,
you're all the time taxing statutes are the most amended tax statutes.
Your Lordship.
And always with retrospective effect. Validating statutes, all that happens only in tax law.
Income tax is concerned.
No. That prevents you, so you all learn from each other.
But Your Lordship may consider that argument.
No, very simple, sir. Just look at the OVAT Act. Carry corresponding amendments in the AET Act and be done with it.
Your Lordship, so far as the common parallels, it is clear. Your Lordship is absolutely right.
Correct.
Because I don't have anything to say.
All right.
But so far as
our limited reference was whether Neelachal Ispat has been correctly decided.
So 9 is concerned.
I'm saying that's the only scope of reference. The reference is only whether Neelachal is correctly decided.
No. Neelachal is not so far as that paragraph 12 and so far as that section 9(2).
Yes.
Your Lordship may consider. Your Lordship,
that's the only reference made to this larger bench.
Your Lordship, para 6. Your Lordship, so far as accept a requirement of acceptance or law, that Your Lordship may decide.
But that's Mr. Mishra. That's the only question referred to the larger bench. You yourself say that has to be answered in the affirmative to say that it's not been correctly decided.
Your Lordship, so far as acceptance.
Yes.
So far as Your Lordship, so far as the acceptance is concerned,
yes,
I should not have any argument.
Correct.
Because Your Lordship, everything has been decided.
Correct.
But Your Lordship, my argument is that whether it is accepted or not accepted, this will not affect section 10.
No. If you want to argue, then we'll take that on board and we'll reject it. So we'll pass that judgment. We'll reserve orders. This is Mahapatra, this is Rautre.
Yes, sir.
We'll reserve orders, but Neelachal will go because of the Keshav automobiles being affirmed with the Supreme Court.
Yes.
Your Lordship, Neelachal is not so far as those aspects.
That's only
not only. There are other issues also have been decided.
In the context of, see, look at the reference, in the context of.
Your Lordship.
All right. Orders reserved.
Obliged you.
All right.
Obliged, madam.
Thank you, sir. Thank you. Good afternoon, sir.
Supplementary list for orders item number 1. My lord. My lord, this is
Millard, in this case, the
Yes.
WPC, Millard, I have filed the CM appeal. I am for.
This is not the case. This
No, wrong case, sir.
wrong.
We are in the,
CRLA 358 up to
we are
2012.
criminal appeal 358.
My lord. I'm appearing, my lord.
Yes.
My lord, an application for bail has been filed that your lordship will find at flag G, my lord. My lord,
Yes.
the earlier bail application was rejected by Justice Sahu being one of the member.
Correct.
My lord. My lord, the case of the prosecution rests on PW2, who is said to be the alleged eyewitness of the occurrence.
Yes.
My lord, may I kindly have the deposition of PW2? Para 2, my lord. My lord, para 1. I know the
Mr. Saurav,
my lord.
page number 14 of the trial court judgment, page number 14, paragraph number 13.
My lord.
There has already been an observation that he is not an eyewitness to the occurrence. I mean, he has not seen the actual assault.
Right, your lordship. So, my lord, the case now rests on the circumstantial evidences.
So she had seen, she is the wife of the widow of the deceased. He had seen the appellant fleeing away from the spot.
Yes, right, your lordship. That is all that is there. That is all the material. And the learned court has gone on to convict me because of 106, my lord. That because I was not able to give an explanation as to why I was running from there, my lord. My lord, it is admitted that the place of occurrence and the house of the deceased are at 300 meters apart with a jungle falling in between, which is the deposition of PW2 herself, my lord. The IO also states the same.
How long has he been in, sir?
My lord, more than 10 years, from 16/8/2011, my lord.
Killed his brother. He has killed his brother, plus. It's a case of fratricide.
Yeah, but it's a circumstantial evidence case now.
Okay. Now it is after PW2.
This is Sahu?
Yes, sir.
All
But one thing you'll he perhaps told that he will prepare the paper book in that order 10/8/2018. That may
My lord,
be
I see
corrected.
that as a noting, my lord. I was not the counsel. Then I'll file the. My lord, I will be filing it today, my lord. I will be filing it. My lord, I'll be filing it by Monday, my lord.
Okay.
Grateful, my lord.
All right. The applicant has been in custody for over 10 years now. The case, after it was noted by the trial court in para 13 of the judgment, that PW2 was not in fact an eyewitness because she is supposed to have seen the accused flee away from the scene of occurrence. The case was approached as one of circumstantial evidence. The argument on behalf of the appellant is that apart from this one circumstance, the other circumstances do not point to the guilt of the accused. Without at this stage expressing any view on the above contention, noting that the applicant has been in custody for more than 10 years, and since the paper books are yet not prepared, the appeal is not likely to be heard in the immediate future. The court directs that the appellant be enlarged on bail, subject to the conditions to be laid down by the trial court and to the satisfaction of the trial court. The application is disposed of in the main criminal appeal. You say counsel for the appellant undertakes that the paper book will be.
Or the fees for the paper books.
Sorry, the fees for preparation of the paper book will be deposited within a week. The paper books be immediately prepared thereafter and supplied to counsel for the parties within 8 weeks.
My lord, may kindly accept my wakalatnama. My lord, there's a prisoner petition to that effect.
Or
So,
you just say
my lord, Sahasranshu Saurabh.
so and so is taken on record.
But one aspect just I'm bringing to lawsuit can I'm sorry I could not bring it to lawsuit notice. Paragraph 14 loss. The internal page 16. There was PW2's version has not been entirely discarded.
No, not discarded.
Yes.
No.
Accepted only to the extent of saying she saw him flee away.
Right.
Yes. Yes.
Grateful, your lordships.
All right. Okay. Right. Good afternoon.
For orders item number 1.
So only extension of time.
Yes, my lord, extension of
All
time
right.
for this.
All right. For the reason stated therein, the time for completion of the disposal of the review is extended
Up to my lord, May, September, end of September, so that my lord.
31st July only what you asked, sir.
You have prayed for 31st July. Consideration, yes, my lord, because my consideration, my lord, I could not be listed because.
No, 31st August is fine. 31st August 2022. All right.
My lord, so far review application is concerned, my lord, I filed on 27th of May. It was initially directed within four weeks, but it was filed, it could not be. Other review application has been extended. For the limitation application, my lord, before the tribunal could not be extended. Now the tribunal is saying unless you get an extension order of filing of the review petition, then I will not allow that. My lord, kindly, my lord, my lord, while disposing the entire revision petition, my lord, your lordship directed within 4 weeks, you file the review petition along with the limitation petition, my lord. Well, I filed the review petition and limitation petition, but with a little delay. Your lordship has extended the filing of the review petition, my lord. But the limitation petition, my lord, on 27th May 2019, it was filed in 19 because, my lord, that point of time, what happened, my lord, the lordship knows, funny was there, funny cyclone was there.
Order. The last order.
Last order. 26.
Not scanned. You already had an extension of time.
Extension of time.
26/9/2019.
Oh.
For filing of the review petition.
And when did you file it finally?
It was filed. It was read, but review petition was filed on 23rd of May. My lord has extended, and we could not appear, my lord. I beg apology for that because of the reason, my lord. There was abstaining of court works, my lord. That is the reason we could not appear. But that point of time, we could not place out the 27th May 2019, 3 days after the limitation petition was filed. That filing of the limitation could not have been extended at, my lord, that point of time.
All right. You say
I have made a prayer.
It is stated that the limitation petition was filed on 26th May.
27th May.
27 May 2019. The delay in filing such limitation petition before the tribunal is condoned.
Yes, sir.
Now the tribunal is requested to take up the review petition.
Yes.
For consideration in accordance with law. And to dispose it off within 4 months from today.
Yes, well.
All right. Okay. The application is disposed. All right.
Yes. 1, 2, 3, 4. Up to item number 4.
Yes, all similar.
All right.
Analog.
Supplementary item number 5.
Item 5.
Your lordship may kindly adjourn this matter to some other day, your lordship. The conducting counsel, he is in the rituals of his father's death anniversary. Your lordship.
All right. Every time we have to sit in a special combination, madam. All right. Counsel for the petitioner is stated, review petitioner is stated to be in some personal difficulty today. We'll have it on 2nd September.
Much obliged.
All right. Right, sir.
Sir, thank you.
Thank you, sir. Thank you. Good afternoon, sir. Namaste. Namaste.
My lord, I'm in item 1.
Yes.
My lord, here, lordship directed for that conciliation process which is ongoing. Now the modalities of settlement has been arrived by the managing director and the petitioner. Now the matter has been placed to the board of directors to take a decision on it. Fine. So can it be called on after 4 weeks so that the decision can be communicated and finally we can go for the settlement?
All right. At the request of Mr. Manas Mahapatra and Senior Counsel, appearing for the petitioner. list on. Again, 2nd September, sir?
My lord.
2nd September. All right.
Item number 2.
May I please, Your Lordship? Item number 2, I am appearing for the petitioner.
Yes.
The counsel appearing for the private opposite party has already filed the counter and needs some further time to file the rejoinder to the active.
There is no private opposite party. Keonjhar municipality has filed it. He has already, your lordship may kindly have 2 minutes. I want to place before your lordship.
Yes.
Your lordship may kindly see basically what is challenged in this writ petition, that is revision of assessment of holding tax by the Keonjhar municipality. That is in exercise of power under section 151 of Orissa Municipal Act. And under section 151(7), this order, this assessment, revision of assessment is applicable.
Oh.
Yeah, I am just placing before lordship the relevant provision 7. An appeal shall lie against an order under section 6 of the district magistrate under whose jurisdiction the municipality is situated, or to such other officer as may be empowered by the state government in this behalf, if prepared by the owner of the occupier of such land and building within 30 days from the date of receipt of the order.
So you can avail of the appeal, sir?
My lord, I am not disputing the provision for appeal, my lord. But my lord, in this case, the rule 5.6b and rule 5.6c of the Orissa municipal rules, which was to be followed by the Keonjhar municipality during the assessment, they have not followed that, my lord.
This point can be raised by the authority.
You raised that in the appeal, sir. You said permitting the petitioner to prevail to avail of the appellate remedy provided under section 151(7) of the Odisha Municipality Act 1950, and to urge all the pleas raised in the present petition in such appeal. The petition
All the
is disposed
inhabitants
of.
have to file in that case, my lord.
Sorry?
All the inhabitants have to file the appeal.
Yes, yes.
Yes.
Absolutely. Absolutely.
Well, 151(7) to be read with 153.
Okay, read with section 153. All right.
He is appearing for the municipal.
All right. Read with 153 of the Odisha Municipality. All right. The petition is disposed of. All right.
Obliged.
My lord, liberty may be granted with regard to the limitation, my lord.
Yes, yes. If the appeal is accompanied by an application for continuation of delay, citing the pendency of the present petition as a reason for the delay, it will be taken into account it will be considered on merits by the appellate authority, provided, however, that the appeal along with the said application is filed not later than 1st September,
Obliged, my lord.
2nd September 2022. All right.
I may be pardoned to mention, my lord, 2 writ petitions relating to that Somalai matters, Somalai Mandir matter. And your lordship has directed that those 2 petitions will be tagged with the original petition in which your lordship has passed a judgment. And again, I had mentioned before your lordship and your lordship, it will come to this court. Again, it was listed before Honorable Justice Vishwajit Mahathi, and he advised us and asked us to again mention your lordship. I pray
Why is that happening? It should be here before this. All right.
That is for 19th September.
No, it can be listed on Monday and it will again go to
19th September. That's what. So those 2 petitions have to be listed before this bench on
Yes,
Monday.
my lord.
All right. All right. All right. Right. Oh, all right. Good afternoon.
Supplementary stress admission item number 1.
Millard, in this case, I am for the petitioners. Millard, the petitioners are the sons and daughters of the deceased petitioner Narahari Jena, who is the main writ petitioner, Millard. And due to non-appearance of the petitioners dated 24/11/2021, when the matter was taken up for hearing, the writ petition bearing number 32417 of 2022 and 2011 was dismissed, Millard, for non-appearance. And Millard, we have filed this CMAPL for restoration, Millard.
What's the main matter about?
Millard, regarding a license of he was a license holder of sawmill, Millard, and the DFO has rejected his renewal application, my lord, under annexure 7, my lord.
How is the cause of action surviving?
My lord,
How does the cause of action survive, sir?
my lord.
How does the cause of action for the main petition, how does the cause of action survive?
Matter of 2011.
My lord. My lord, 2011, my lord, the right to sue subsists, my lord.
What is that right to sue?
Right.
Where's the question of right to sue?
He means legal heirs are entitled to sue the case. That is not the dispute. Whether the cause of action for the
Survives.
case.
My lord, 2011 they have filed, my lord. But after that, after the death, they have filed substitution petition, my lord, for IA number 10997.
But how does the cause of action survive? How does the cause of action survive?
My lord, since that is a continual process, my lord.
What is a continuous process, sir?
My lord,
There is no interim order. There is no interim order.
my lord,
At no time was there interim order passed for renewal of sawmill license. There is no question of renewal after so many years. There is no interim order.
during that time, their father filed the writ petition, my lord.
That may be, sir, but there is no interim order in the writ petition. So there is no renewal of license. For 11 years, there has been no renewal.
And in the meantime, Sawmill Soffit Act has undergone many changes. And let him renew his prayer if at all cause of action survives.
All right. You say for the reason stated, the same APL is allowed. The order dated that November 21 is recalled and writ petition 32417 of 2011 is restored to file. And then you say in this CMAPL 10997, for the reason stated, the application is allowed and the LR for the petitioner are substituted. The application is disposed of. In the main petition, you say it is seen that the prayer in the present petition is for a quashing of an order dated 11/9/2010. 11 November 2011 of the licensing officer cum DFO, Bhadrak Wildlife Division, Chandbali, declining the prayer of the petitioner to renew the license to operate the sawmill in question. Full stop. During the pendency of the present petition, there was no interim order. In fact, the petition was listed just once on 26/9/2013 when notice was not issued. Full stop. Consequently, the court is satisfied that the court is not convinced that any cause of action survives for the LRs of the petitioner to pursue. Full stop. In the event any cause of action survives, it will be open to the LRs of the petitioner to agitate the grievance in a separate substantive petition in accordance with law. The petition is disposed of.
Item number 2. Regarding sufficiency of a notice, my lord. Notice was issued in the same APL. And my lord,
What's the main petition about, sir?
My lord, writ petition has been filed challenging the order of the ombudsman, my lord. My lord, granting, saying that without assigning any reason, my lord, the ombudsman has passed order on the annexure 5, my lord, on annexure 6, my lord, that you grant him the TOD benefit of 1/3 consumption of the energy every month, starting from 2007 to 2009, my lord. My lord, what happened, my lord? This OP is an industry, my lord, and my lord, he was availing electricity and paying the dues. And my lord, 2010, my lord, when a upgradation in the context of upgradation technology, a new meter was installed.
Who is appearing for him? Some BK Nayak.
My lord, I am appearing for OP number 2.
My
My lord. Opinion. Lordship, I have not received the CRLMP.
That's okay. You just wants restoration. Are you aware of what has happened at actual ground? What is happening? Because there was a stay of the ombudsman's order throughout in this court.
My lord.
What is the current position? Is this industry still working, not working? What is it?
Milord, when the area was the 2 crore, Milord, the industry line has been under disconnection. Now it has become 6 crores and above, Milord. And in a writ petition filed before this honorable court, the honorable single judge has passed order that if you deposit rupees 2 crore out of that 6 crore, Milord, power supply will be restored. He himself writ petition pending after an interim order. But till date, he has not complied with that and not available power supply because he did not deposit the amount.
So which means he's closed. So what does it matter whether this order is there or not? He's not going to be able to avail of anything.
No, there is no need. He is representing that you grant me this benefit and deduct this amount from my area, total area, Milord. Because he is not entitled to this amount, Milord. Because it is a, Milord, this order is without any reasoning, Milord. Milord, TOT.
For the reason stated therein, the same appeal is allowed. The order dated 6/12/2021 is recalled. And writ petition civil 23500/2010 is restored to file. In the main writ petition, you say, counsel for the opposite party number 2 seeks time for instructions on the current status. Interim order to continue. List on 12th October. Oh, all right.